May I please, your Lordship? Yes. Lordship, in item number 28, Lordship. Lordship, we have got instruction to appear in this matter, Lordship, and we are filing our wakalat number today or tomorrow, Lordship. Lordship, may kindly post this matter, Lordship, after 2 weeks.
28
Lordship.
for the petitioner,
Lordship.
Mr. N. Sharma.
N.K. Sharma, Lordship.
N.K. Sharma on instruction submits that they are recently engaged in the matter, therefore require some time to complete their instructions. Matter stands referred to be listed after 3 weeks.
Lordship.
Yes.
Deeply obliged, Lordship.
My lord, this matter may be listed for motion, my lord, on 31st, my lord.
Why?
And in the matter relates to compassionate appointment. Lastly, it was listed before vacation, and there was an order for listing the matter after vacation, but it has not been listed, my lord.
Let it come next week,
Yes, my lord.
7th.
Another matter, my lord, another matter. This is for hearing. Earlier, it came for hearing in the first, my lord, part 1 list, my lord.
Let it come for orders 7th.
Well, I'm
Yes,
praying for
sir.
listing this petition, my lord, on Friday.
Hmm?
Because, my lord, the petitioner is retiring on Friday, my lord, on 31st.
What were you doing all these days?
My lord, I was out of station on 15th. That is why, my lord, it was listed on 15th, my lord.
Hmm.
But I was out of station for which, my lord,
It can't be on. What are you praying for?
I'm praying for listing this matter, my lord.
No, you said your client was retiring on Friday.
He was he's retiring on, my lord, 31st of.
So what
which
are the
month, my
prayers
lord?
in the
My
petition?
lord, I'm praying for promotion in this case.
Oh,
My lord,
let it come
I'm
in.
holding the, my lord, promotional
no,
post,
let it
my lord, on
come.
in-charge basis, my lord.
Let it come in 14 November. What notional promotion? He's retiring. You want his promotion to be there before Friday, by the time he retires.
I am holding the post, my lord, on, my lord, in-charge basis. My DPC was held. Only, my lord,
14 November. 14?
May please, your
Yes.
Lordship, I'm praying for listing of a matter also on Friday. It was for
Why?
Lordship, this is for pensionary benefit. Lordship, her husband died in 2021.
Pensionary benefit, let it come in the month of November. 12th November. Yes.
Obliged.
Please, your Lordship. Lordship, I beg for listing of a matter, my lord, a writ petition, my lord. It is a prayer for accelerated promotion, my lord. And recently, my lord, they are going to give promotion to my which I have challenged, my lord.
7th.
7th, my lord.
Yes.
Yeah, please, your Lordship. Lordship, I beg to mention a matter for listing for admission. Lordship, is a family pension matter. Any date up to your Lordship's convenience.
7th.
7. Much obliged.
Notice for item 27, SMS slip was circulated, and with the consent of the other side, I'm praying for
27th. On the. No. 27, we are not adjourning.
No, Lordship, Mr. Kumar is not here because of bereavement in his family. Because of bereavement in his family, he's
You
not
are
here.
taking one ground or the other. What is this?
No, Lordship,
In spite of having the matter listed,
yes, Lordship, but this was unforeseen.
he's not there. You engage somebody else. It's not a private brief. It's a state brief.
Lordship, I take it up on Thursday.
This is not done. This is a part-heard matter. You are seeking adjournments for the last 3 months. 27 on Thursday. The request made by Mr. Ghosh on behalf of the PNRD department. Yes.
Lordship, I beg to mention for listing of withdrawal of writ petition for tomorrow.
Tomorrow.
Must oblige.
Seek my lord's indulgence to mention a matter for listing tomorrow.
Why?
These are similarly situated discharge orders.
Not tomorrow. Let it come on Friday. Let it be on Monday. Why tomorrow?
Other matters similarly situated, those are listed tomorrow.
Is it?
Yes, Lord. It's
All right.
listed before your lordships.
All right, tomorrow.
Much obliged.
May I please, your Lordship? Lordship, I beg to mention item number 29.
Item number?
29. Lordship, one of the family member of the engaged counsel expired today. So kindly matter will be adjourned for the day. And
On whose behalf you are making a mention?
NK Kolita.
NK Kolita. Item 29 and it stands adjourned to be listed after 4 weeks on a mention made on behalf of Mr. NK Kolita that the counsel of the petitioner is bereavement. Yes.
Lordship, I beg to mention for listing, pensionary benefit,
Pensionary benefit, for admission,
admission,
12th November,
the first,
12 November,
1st November.
12th.
Must,
May I please, Lordship, I beg to mention for listing a writ petition for orders, Lordship, any date? Next,
Any date. Any date, let it come on 12th.
oblige.
Lordship, beg to mention for listing of an WPC. It was last listed yesterday, but as my senior.
Yesterday,
Lordship,
yesterday we must have passed some order.
Lordship, it was given after 2 weeks. Lordship, finally this weekend.
You give the item number, we'll check up. You give the item number, yesterday what orders were passed, we'll have to see. What order was passed?
53, Lordship.
You give the number to the court master, we'll verify and then we'll decide. Yes.
May I please, Your Lordship? There is urgency in this matter. It's a writ petition. The order has been passed on 2/4/25, and till now it's haven't listed again.
Still now?
Haven't listed, has not listed again.
12th November,
Your Lordship, can we list it on 30? 30?
not 30. Not 30. 12th.
My please, Your Lordship. Your Lordship, I beg to mention one writ petition for listing in orders column, Lordship. It has been last posted in 2022, Lordship. Can it be on Friday?
Not Friday. Let it be on 12th November.
Bless. Lordship, book matter was passed over for the day. Lordship, kindly this week any day.
Passover, it will come next week. Or on Friday, it will come.
Friday, Lordship.
We are not allowing your mention. We have directed the matter to be passed over, it will come. When the registry will list, either tomorrow, either on Friday or on next Monday. You don't have to mention.
Lordship, this is with regard to item number 21. We have circulated the adjournment request and we have gotten requests from all the petitioners. My senior, he is appearing in the Itanagar branch. Lordship may kindly take up the matter on 27th if possible.
This is 21.
21.
This is a series, my lord.
From 19.
From 9.
From 19, it's a with matter. 19 to 21.
This is the series from 19 to 26.
What is to be done?
That informed the inconvenience.
We are thinking we'll dismiss your petition today.
So my senior would like to make a submission in this matter. So he is appearing in the Itanagar branch. So if your Lordship may kindly take up this matter on 27th.
27th, oh?
27th of next month.
Well, 19, 20, 21 are connected, my lord. The rest, my lord, they pertain to termination, but are.
Who is mentioning in which matter? 21.
21, just 21.
But they're all connected.
They're
Or
tagged
it is
together.
found to be connected.
Yes.
Two different sets of petitions.
Oh. Which date are you seeking?
But the consensus arrived at was 27th of November.
27th of November. It's better to release it from part head. Why? We forget everything.
Or else it can be on a earlier date
Earlier
also.
date, because it was released twice, my lord, by different bench.
In that case, let it be on, my lord.
Released twice.
Yes.
By which court?
Lord, court.
Earlier court. This is not this court.
No, not this court.
Okay. So let it be for the third time.
Let it be on, in that case, let it be on 18th. 18th. What will be?
Yes.
18 November.
18 November.
Right.
Tuesday. Let it be on 18th of November.
No, you want 27, all right. We'll give you 27. These are for admission, not hearing.
Yeah.
Hearing matters.
Mal.
All right, then we can take it up on 18. 18th. 18 November. In terms of the adjournment request circulated, on respect of item 21, which is connected to items, which is a part of the series, item 19 to 26. These matters stand adjourned to be listed on 27th of November. Yes,
27th is more.
27 November. All right.
Yeah, please, your lord.
27.
May I please, your lordship, my prayer is for listing lordship, the matter regarding compassionate appointment lordship. Last date matter was listed, but
12 November.
much obliged.
Supplementary list for 12 item 48.
Heard counsel for parties on the instructions received by the counsel for the parties. Petitioner, writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. On instructions received, counsel for petitioner submits. The writ petitioner does not wish to press the petition any further. Accordingly, the same stands dismissed on withdrawal. Interim orders, if any, will stand vacated. Yes,
I am appearing for all respondents.
Ms. S. Borwai appears for all respondents.
May please, lordship, may please, your lordship, when we filed the writ petition, an appeal was pending, lordship. And in the meantime, the appeal was disposed of by an order dated 8/8/2025. So lordship, I kindly request you to allow us to withdraw the matter with liberty to file a fresh, lordship.
Liberty to file with liberty. Yes.
Can we read to others, that is 1 to 12?
Item 3, item 8, and item 10. We have already dictated orders. I think we can
Item
upload
number
these
3,
orders anytime
Item 3, I'm appearing.
by this week.
3, 8 and 10.
3, 8, and 10. So once these orders we upload it, have a look, and if the other matters can be closed in this line, we'll close it.
Lots.
We wanted to deliver it today, but some corrections are
Lots.
required. So hopefully by the end of this week or Monday. All right, so we will defer these matters to be listed again on these are for admissions.
Admission.
Admission, you know this. Admission, what do you?
Admission.
Eight orders.
And the orders.
Is a orders. Have it on,
Orders. Lordship listed in orders column.
huh?
All the matters have been listed in orders column.
So orders means, I think, why are they listed for orders? Okay, for delivery orders.
Yes, delivery report.
So we'll have it listed on 13 November.
Lots.
Right? 13 November.
Lots. Much good.
List all these matters on 13 November.
For admission, item 13.
Lordship, here in this matter, Lordship, I have received instructions, Lordship. I need 2 weeks time to file my affidavit, Lordship.
13 May to?
13. I see.
Let's see, petitioner is a paid end of his life, my lord. More than decade earlier, he was retired, my lord. Still not finalized the pensions, my lord. And no reply, my lord. From 2000.
What instructions have you received?
Lordship, I want to bring it on record, Lordship, by way of an affidavit, Lordship.
File it within 1 week.
Yes, Lordship.
Yes. Let it be
Yes,
filed within 1 week.
Subject to lordship convenience, my lord. A date may be fixed, my lord.
D. Upamanyu, Learned Counsel, appearing for the Health Department, submits that instructions have been received. Would like to bring it on record. Let this affidavit be filed within 1 week. Mr. M.U. Ahmed, Learned Counsel, appears for the petitioner. Let this matter be listed again on 14th November,
14th of November.
14 November.
Obliged.
Highly obliged.
I'm question number 7, 8, 9, and
Mr.
10.
Boro appears for
7, 8, 9, and 10.
7, 8, 9, and 10.
In this matter, Lordship, to take for in the cover case, Lordship, and Lordship's water dated 21/8, Lordship wanted to know whether the original water has already attained finality or not. 21/8/23, Lordship. But they have been directed, Lordship, whether the original water has already attained, Lordship.
Last
finality.
order is 19.
Last order is otherwise, Lordship, regarding maintainability, Lordship.
So,
the petitioner has not made the selected party as a respondent. And
What are you-
also pursuant to an earlier order, my lord, a batch of writ petition was, my lord, the 166 person moved the writ petition. Lordship kindly see page 76 is a relevant portion. While disposed of the matter, my lord, respondents are directed to consider the case of the petitioner for their appointment to the post of AB constable or in the equivalent post in the vacancy available or current next available vacancies. If the vacancies are limited, the petitioner will be considered in fresh manner till all them are considered. If it is found that the petitioner in the meantime have become overaged, there is may be relaxed. It may be made clear that the respondents without considering the case of the petitioner shall not fill up any post of armed force constable. These are the observation made with the petition disposed of. So pursuant to this direction, my lord, a speaking order has been passed by the my lord authority, and this order has been, my lord, has given details. Actually, in Sibsagar district, 156 posts were allotted. Out of that, 8 posts was reserved for 5% quota for compensation appointment. And out of thereafter 148 posts for contesting by the candidates. And out of that, my lord, this list has been shown. Either petitioner, some are failed in the physical test and some are got marks below the cutoff marks. There is a chart, my lord, and this order.
But you have not filed your counter affidavit.
My lord, each my lord, this has
Or-
speaking order has.
For you to address the court, at least you must have the minimum pleadings so that we know what is your objection, what grounds you are making your objections, raising your objections. Why have you not filed an affidavit if you are questioning the maintainability?
Yes, yes. Yet, my lord, correspondence was made, but we have not received the instructions, my lord. So sometime may be granted, my lord, I will obtain instructions, my lord.
Or otherwise, Lordship may dispose of the matter directing them to examine the Lordship in either way, Lordship.
No direction in what terms?
In terms of the Lordship similar to.
Which orders?
Page 80, your Lordship is 76 and 80, your Lordship. 76 is the original direction, your Lordship, and by quoting this, your Lordship, another writ petition has been referred. This is relevant part is page 79, your Lordship. Only let them examine, your Lordship, whether we are within the ambit of this Lordship or not.
Whether you are even entitled to this order has been questioned.
This order also says situation those petition WBC number 2725/2010 by issuing a speaking order during a period of 1 month. Accordingly, this speaking order has been passed. The speaking order says, my lord, either they are getting less mark in the, my lord, physical test or in the viva voce test. They are below the cut-off marks. And all the petitioner were informed by sending this order.
You wanted to file the writ petition, earlier writ petition. Then you see what grounds the second writ petition was allowed?
Lordship. Understood.
Then you don't fall into that category. It is not your case.
They have been claimed that they were in the earlier reputation by somewhere their names were not included in this.
No, you file your affidavit. Heard counsel for parties, Mr. T.C. Sutial, an advocate, has prayed for further time to complete his instructions. It is made clear that if the affidavit as prayed for is not filed, consequential orders may be passed by the court. Least after 3 weeks.
Obliged, my lord.
Obliged.
Lordship, for timing, Lordship. And Sharma on legs, Lordship, for timing, Lordship.
Lordship, senior counsel.
Yes. You worked as master roll workers.
Work charge.
Work charge.
Work charge.
Brought into regular cadre.
The appointment says that you are appointed temporarily in this scale.
You worked for all these years, then superannuated.
They have said in the last letter that you are superannuated.
And no pension.
Yes, no pension except pension, everything else is good.
So your prayer before the court is that you should be treated as a regular employee and pension.
They have treated, therefore I am asking for a declaration that we were treated as a regular employee. From the facts, it is absolutely admitted. And I was put in the scale, increments were given, regular efficiency bar has been crossed. There is no problem, and work charge means will not be classically that you are charged to a particular work. It was not so in our case because we have served for long years, and it was from different works as a regular normal worker. So there is no question of or being a, that is a level, your lordship have to lift the level. And in this case, even lifting is not necessary because the orders are clear. Appointment letter is there, the service record is there, and the final superannuation letter is there. So I'm absolutely, there is nothing except that the pension, they are giving everything. And pension is, as your lordship see, it's not a bounty. I'm entitled. And in our case, my lord, so far Sam is concerned, there is a set of rules and a rule, and then pursuant to that power in the rule 31, there are 2 notifications which you have annexed. Your lordship has seen those. And said that it is only the number of years which is required to be complied with in order to get pension. 55 and 57. And your lordships may note that we have had cases on pension from this High Court. And in none, they have referred to these relevant 2 notifications. They were very relevant so far as the type of work which these people worked and did. So your lordships will not find any reference to any of this in any of the judgments. And it is to the credit of my learned friend, my lord, who, while drafting the petition, focused it and annexed those two documents. It is his innovation in a way to project the case on the basis of these notifications, which was never done before this court earlier. Therefore, this is a new aspect. But the Supreme Court judgments have also virtually, starting with Prem Singh, there is a different trends visibly available, which is, my lord, supplemented by two judgments recently. Last one by Vikram Nath. My learned friend was referring to two judgments, I think. No? Two judgments. After the judgment was reserved, my lord.
What were the judgments?
This is, my lord, one was Sunita Burman, the other was Vikas Roy. So far Sunita Burman is concerned, that was in widow's case, and this Vikas Roy, our own court here, but there is no reference to, my lord, Rule 31 and the notifications in question. And in fact, this case, which was Vikas Roy, the learned judge, my lord, relied on, my lord, Uday Pratap Thakur's case. That has subsequently been overruled by the Supreme Court itself. Therefore, my lord, this judgment really cannot be relied on by your lordships. And Sunita Burman also, it is a case relating to rules of Orissa.
What were the judgments? Sorry, you respondent, what were the subsequent
Two
judgments?
judgments, my lord. One is our own court, Vikas Roy, WPC 5931 of 2021.
We don't have the judgments.
Lordship, I have furnished.
I remember you furnished.
Yes.
But it is not here.
Because
Huh?
I didn't part with my copy.
WBC number तो
WBC 5931 of 2021. Last paragraph, your lordship will find. Para 18, page 13. Applying the ratio of decisions of the Honorable Supreme Court in the cases of Uday Pratap.
We just get hold of the judgments. This is Vikas
Roy, that is our High Court singing here.
Yes.
That was relied on, 18, para 18, last page. Now, Uday Pratap has been overruled. I'll give you a lordship the. Want to be? It is. Orissa. Yes, in the words. Uday Pratap.
Overruled by this.
Look, the history is like this. Uday Pratap is, 2023 SCC Online SC 527. It tried to limit Prem Singh. But it was a different question altogether as to the whole thing was whether the entire period of service will be taken into account or only the portion after, because there is a rule there where regularization was permissible and on regularization pension is given. So that was dealt with, and that was ultimately Prem Singh was.
This is one judgment, and what was the other?
The other judgment was Milot. Sunita, no. Uday Pratap and Sunita.
2023 1 SCC 570.
Yes.
Print out.
Sunita Burman. Copy. That's next.
Take a printout.
2023 1 SCC 570. Lordship, this is a subsequent judgment to subsequent to Prem Singh Lordship.
Yes.
Prem Singh was discussed and thereafter court arrived at a conclusion that no, all the three conditions in the Umadevi case are absolute necessary.
This is also another case, my lord, which turned on the service rule available in that state. And it was not the state government, it was the MP Housing Board. And para 12, your lordships will find the rule was not adopted by the board in that case. And page 574 and 575, government rules do not apply. That is the finding.
In Sunita Devi,
In Sunita Burman.
Sunita Burman,
Yes.
sorry.
It is absolutely a different sort of question because a board, housing board employee and a widow of that, whether she'll be entitled because her husband was not regularized, therefore it was said that she will not be entitled. But regularization was needed in their rules. And it is the finding that para 12,575 that this board never adopted those rules and government rules do not apply, page 574 and 575. And at page 577. So these stand only on the relevant rules concerning the state. And the other case was below state of. This is going to Uday Pratap. No, Uday Pratap to go. And the other case relied on is Uday Pratap, my lord. By the respondents. Well, 2023 SCC online SC 527. So Prem Singh was limited. And the question was as to what is the extent of the service which will be taken into account for determination of pension, which is not our case here. They limited the Prem Singh to the extent of saying that it is only after regularization that it will be counted. But that turned on their own rules. And this Uday Pratap, so far as the effort was to dilute Prem Singh was concerned, that was dealt with subsequently in Miller 25 to 2025 SCC online SC 385. We have given the copies below. And in para 13, page 31.
What are the subsequent judgments that you have?
Milord, the first case they are giving is Uday Pratap. That is, Milord, reference is 2023 SCC online.
So you give us the
We have provided the list of judgments.
list of judgments
By
today.
petitioner, Your Lordship.
They have given
We have handed over the copies of the judgment. Your Lordship.
after the reserved judgment, Milord, they
But
have
the
given
recent
two
judgment, we don't have it.
They have given two judgments, one of the High Court, which is Milord, Vikas Roy, no?
Because,
Vikas Roy. And the other is Milord, Sunita Burman, by the respondents. Two
Which
judgments have been given.
judgment do you now say has referred to Prem Singh? No, sorry.
Uday Pratap.
You mentioned the 25 judgment now.
Yes, Your Lordship. 25.
Yes, 25 Dharam Singh, Milord.
What is the citation there? There is no citation.
There is an online copy, Your Lordship.
Online copy.
I will provide the copy, Your Lordship.
Give us the date of the judgment at least.
This is
19th of August.
19th of August 25. Recent judgment. Milord, sequence wise, Milord, the Uday Pratap, which is being cited now, that was overruled in State of Odisha versus Sudhanshu Shekhar Jena, which is below 25 SCC online SC 385. Your Lordship has got the copy? Because
2025 SCC online.
SCC online 385.
This is State of Odisha versus
Sudhanshu Shekhar Jain.
That dealt with the earlier case cited by them now, Uday Pratap Thakur and another versus State of Bihar.
yes.
That is 2023 SCC online SC 527. Your Lordship has that. So they tried to limit Prem Singh, although the question is on a different thing, but that has been overruled by State of Odisha versus Sudhanshu Shekhar Jena, 25 SCC online 385, which your Lordship has just got it. And para 31, para 13 at page 31, your Lordships will find that the court has said that Uday Singh has not been correctly decided. Uday Pratap was therefore overruled to that extent. So your Lordship did not be.
What about the Vinod Kanji Bhai?
Huh?
What is the judgment 24?
No, they have given now two judgments. This is our case, we have cited it before your Lordship.
Immediately.
Yes, this is 24th judgment, 24 Supreme Court SC 115, Agara versus State of Gujarat.
No, there is a particular matter, there is a citation here, which is Vinod Kanji Bhai.
Vinod Kanjibhai. This is Milord Vinod Kanjibhai Bhagora.
Bhagora. This is for what proposition?
I don't know. We have cited this case.
You have cited, therefore we are asking.
Yes. Para 17, Milord. These are all actually different, Milord. He was serving elsewhere, and he came to the.
So your case that you are projecting is that you are working as work charge, then regularized. You had
There is no requirement in our rules about regularization. If your Lordships.
Your initial appointment was to which post?
Your Lordship has the appointment letter, work charge employee.
Work charge.
Yes. Second assistant.
25.
Is work charge defined anywhere under any rules?
There are so many judgments, Lord.
No,
So
judgment.
many, right? Not from the judgment of Jiten Kalita. And till today, Lordship, I can place so many judgments.
No, I don't want any rehearing of the matter. You have
Placed
placed whatever you have
judgments,
placed.
at least. Let us be clear of what is a work charge.
Lordship, if
No, kindly turn to page 25. This is our appointment letter.
25, yes.
In the interest of public service, Sri Pramod Kakoti is hereby appointed as work charge section assistant in the scale of pay of 1065 so to up to so much, plus other allowances as admissible under the rules. In Boko Road subdivision, the appointment is purely temporary and may be terminated at any time without notice. This is the appointment and the term, then thereafter, my lord, we got the scale. Our service book is open. Annual increments are given. All other allowances are given as given to a regular employee. And we are not stuck to this particular place. We rolled on to different places, different works, like a normal laborer, employee. And at page 48, your lordship gets the normal, the superannuation letter. At page 48, your lordship will see this sample. So work assistant, section assistant of PWD Guwahati East Road subdivision under the division is hereby released from the government services with effect from 31/3/19 on attaining the age of superannuation. This is all that has happened. And we are given everything except pension. Because we are not taken by it. And your lordships will see the two notifications, page 55 and 57. We are governed by our rules, pension, Assam 69 pension rules. Rule 31 is a part of that rule, which authorizes issuance of notifications, and these two notifications have been issued by the state government. Office memorandum dated 12/9/96. The pensionary benefit to the state government pensioners, family pension holders. In the Government of Assam circular issued under office memorandum dated so-and-so, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. The said OM came into force with effect from 1/9/82. The governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under the governor of Assam, fulfilling the criteria of not less than 20 years of continuous service, will be eligible for pension from 1st September onwards. This is, however, subject to condition that they satisfy all conditions other than the conditions of permanency against permanent post under Government of Assam for usual pensioner benefit under the Assam Services Pension Rules. This benefit not be admissible to any retirees who retire before from the service with retirement benefits under CPF, that Contributory Provident Fund. And in page 13, your lordships may note, we have said that we have no CPF account. So this is the first in 96, reiterated at page 57 in 2003. It is not modified these notifications. At page 57, if your lordship see, in continuation of this notification dated 12/9/96, which your lordship has seen at page 55, it is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. Can anything be more clearer than this, Miller? The focus is on 20 years of continuous service. It is reiterated thereafter. After rendering 20 years of service, if the government servant is superannuated or incapacitated or is dead, is not a root point. Any confusion in this regard is against the spirit of the OM referred to above. It is therefore clarified that pensionary benefit as contemplated in the above OM shall be admissible to a government servant who died after rendering 20 years of continuous service, or other terms and conditions of eligibility shall remain as usual. And the conditions of Rule 31, your lordships have seen that. In the pension rule of 69, I just read out, the service of an officer doesn't qualify for pension unless it conforms to the following three conditions. The service must be under government. Obviously, it is under government. Secondly, the employment must be substantive and permanent. That the notification has exempted.
Huh? Just a minute. Huh? Confirm korilo. Some of the judgments I'm informed are not available. So Mr. Das will find out what judgments you are relying on. Give us as per the list.
Yes, sir.
As also for the respondents.
No, you give at least these two judgments and these judgments. I was referring to Rule 31, Milo.
এটা লিখন মই তাতে লিখি দিছো হাতেদি সেইখনে ৰিটেন কৰিব Yes, Rule 31.
The service of an officer doesn't qualify for pension unless it conforms to the following three conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Thirdly, the service must be paid by the government, provided that the governor may, even though either or both of the conditions 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension, and in individual cases and subject to such conditions as he may think fit to impose in such, each case shall allow service rendered by an officer to count for pension. So these notifications under this power, Miller. And the service must be under the government, that is obvious. The employment must be substantive and permanent. Permanency is not required. That is the effect of the order. That the core question is that how long you have worked. If you have worked for 20 years, you are entitled to pension under the notification. That's the power of the state which they have exercised. And service must be paid by the government. Obviously, we have been paid by the government. Who else will pay? And Dharam Singh is important, Milord. That is the last case.
Yes.
And your lordship was referring to that Kanji Bhai. There also in para 17. Para 17 at page 4, Milord. It is well settled that pension schemes floated by the state government form a part of delegated beneficial legislation and ought to be interpreted widely. Subject to such interpretation not running contrary to the express provisions of the pension rules. Senior divisional mention LIC versus so-and-so. Furthermore, it would be relevant to understand that the state government is a model employer and ought to uphold principles of fairness and clarity. You issue notifications in 93 and 96 and say that if your core issue is that have you served for 20 years or not? If you have, you are entitled to pension. That is your own notification. And what is substantive and permanent is also mentioned in the judgment we have cited below, that Justice Ayer's judgment. That is
1984 SS.
1980, I cited this case. 1980, volume 4, SSC 226. Para 29 at page 241 and at page 243. This is not something, my lord. Oh. Para 29 at page 241.
Yes.
Substantive capacity is a flexible expression which cannot be frozen by current official eyes, nor by the conditions that obtained in the remote past when the rule was framed. On the contrary, its meaning must be consistent with Article 16 and must avoid the pitfalls of arbitrariness and irrational injustice. So view do you hold that the appointments need not necessarily be to a permanent post. It is sufficient even if it is to a temporary post of long duration. In a department which has permanent post and temporary posts of a quasi-permanent nature, there is not much of a distinction the quality of service has between the two. Potawatomi's case, that 77 judges case, Sohan case, have primarily in passing clarified the equal value of officiating service. In Potawatomi's case, Chandrachud J, as he then was observed in the course of discussion, that there is no universal rule either that a cadre cannot consist of both permanent and temporary employees, or that it must consist of both. Later, the learned judge observed in the same strain. The fact that a permanent strength of the cadre was determined on the basis of permanent posts at any given, that is not necessary. Kindly turn to the next paragraph. The court in that case also held that confirmation cannot be the sole touchstone of seniority, as that will be indefensible. Confirmation is one of the glorious uncertainties of government service, depending neither on efficiency of the incumbent nor on the availability of substantive vacancies. A glaring instance widely known in a part of our country is a distinguished member of the judiciary who was confirmed as district judge years after he was confirmed as a judge of the High Court. That is the state of affairs, Lord, everywhere. It is on the record of these writ petitions that officiating deputy engineers were not confirmed, even though substantive vacancies were available, in which they could have been confirmed. It shows that confirmation doesn't have to conform to any set of rules, and whether an employee should be confirmed or not depends on the sweet will and pleasure of the government. That's why, the notification is also very clear in our case. And for the first time, your lordships, if I may say so with respect, for the first time in this court, your lordships will be dealing with these two notifications while considering the case of pension of this type of workers. All the judgments your lordship has seen, we have also to large extent gone through. Nowhere these two notifications have been referred to. And in view of the language of these two notifications, my lord, in my most humble submission, there is no scope for denying pension to a person in government service for 20 years. It will be absolutely unfair and opposed to the very concept of pension, because concept of pension is, my lord, that it's not a bounty. It is his right to get for the service he has rendered. You treat him as regular all through. Give him the scale. You give the normal increments. You treat him like a regular person. Transfer him. And then say that you have reached the age of superannuation. And everything else is given except pension. And kindly see this Dharam Singh, that is the last and...
Does it not presuppose some relationship between the employer and the employee in the nature of a government servant?
Obviously.
To entitle you for pension.
Obviously. The letter of appointment is by the government.
So the employment has to be, you see, this is another way to clear certain doubts.
Huh,
The argument that you're making
yes,
is that so and so was appointed
yes,
in the particular service.
yes.
Now, any government service,
Uh,
there is a set of rules governing the services.
Correct,
There is a procedure prescribed for inducting employees into the
Correct.
service. None of these are followed in your
of
case.
course, we have made the environment that is not denied.
You have appeared for selections.
We were appointed according to the procedure prevalent at that point of time. That's the environment we have made in the writ petition that is not denied. And they have opened the service record. They have annual increments have been given. Everything is recorded, entire our service career in these service records. And finally, they said that you have reached the age of superannuation after more than 20 years, below, and they retire. If these letters of appointment are not government servant, below, what else will be? Pursuant to these letters only they have served. Their service, their payment, their entire career emerges out of these two, this letter of appointment, finally terminated by the superannuation letter. One can't be super technical in these matters. If the rules permit the pension, Milot, why should they not be getting it after their service? Without any blemish.
The rules talk about substantive and permanent posts.
Correct. That is, your lordship has seen in the notification. That is not required. That's the exemption given.
What is your
And what is permanent and substantive that Supreme Court judgment takes care?
what is your response to these notifications?
Nothing. They don't follow their rules. That's all. They have never denied or disowned the notifications. How can they? The Dharam Singh is important because some will tell me.
First paragraph.
See the language below. Very good judgment. When public institutions depend day after day on the same hands to perform permanent tasks, equity demands that those tasks are placed on sanctioned posts and those workers are treated with fairness and dignity. The controversy before us is not about rewarding irregular appointment.
Exactly.
It is about whether years of ad hoc engagement, defended by shifting excuses and pleas of financial strain, can be used to deny the rights of those who have kept public institutions running. We resolve it by insisting that public employment should be organized with fairness. Reasoned decision making and respect for the dignity of the work. And this is at paragraph 3, there was that the appellants were engaged on daily wage basis and there were no rules in UP Higher Secondary Service Commission. Respond for regulation. Moreover, the court observed that no vacancies existed against which the appellants could be accepted. Considered. Factual backdrop to the present appeal is as follows, and they go to the fact. We are not concerned with the facts. Longest judgment. In para 7, my lord, the Supreme Court deals with the High Court's, my lord. The original writ petition before the High Court expressly assailed the state's refusal dated so to sanction posts for the commission and sought a mandation for creation of posts and all that. The single judge of the High Court and the division bench of the High Court in appeal treated the matter as a bare plea of regularization, answered it only on the touchstone of absence of rules and vacancy, and rested principally on Uma Devi. In so doing, the courts below failed to adjudicate the principal challenge to the state's refusal and the legality of its reasons. In our opinion, such non-consideration amounts to a misdirection and in effect a failure to exercise jurisdiction. This is what is said, Milan. The state's refusal of so-and-so cites financial constraints and the subsequent decision of so-and-so, that is on the facts below. Last 4 lines are important. We believe that a non-speaking rejection on a generic plea of financial constraints, ignoring functional necessity and an employer's own long-standing reliance on daily wages to discharge regular duties does not meet the standard of reasonableness expected of a model public undertaking.
Yes.
Then it says that the functioning is a uninterrupted and a continuous regular thing, and it is perennial. Next page, last part. That consistent internal demand coupled with uninterrupted utilization of the appellant's labor on regular office hours fortifies the conclusion that the duties are permanent, perennial. To continue extracting such work for decades while pleading want of sanctioned strength is a position that cannot be sanctioned. It is the clearest possible statement from the Supreme Court. And kindly turn to para 11. Furthermore, it must be clarified that the reliance placed by the High Court on Uma Devi to non-suit the appellants is misplaced. Unlike Uma Devi, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state's arbitrary refusals to sanction posts despite the employer's own acknowledgement of need and decades of continuous reliance on the very workforce. You continue to take service more than for 20 years and then say it's not a permanent post. And the court will accept that. This is the authority to say that this is absolutely humbug. On the other hand, Uma Devi draws a distinction between illegal appointments and irregular engagement and doesn't endorse the perpetuation of precarious employment where the work itself is permanent and the state has failed for years to put its house in order. Recent decision of this court in Jagu Sripal have emphatically cautioned that Uma Devi cannot be deployed as a shield to justify exploitation through long-term ad hocism. The use of outsourcing as a proxy or the denial of basic parity where identical duties are extracted over extended periods. The principles articulated therein apply with full force to the present case. The relevant paragraphs of Sripal, that is quoted, which we have already submitted before your lordship earlier. Extensively quoted below. We have placed this case before your lordship earlier. E2? No, E2 case. Dharam Singh is the recent latest case. Sripal earlier we cited them. Then paragraph 13, Jago is and Sripal. Paragraph 13, it comes to the conclusion, as we have observed in both Jago and Sripal, outsourcing cannot become a convenient shield to perpetuate precariousness and to sidestep fair engagement practices where the work is inherently perennial. I am needed for them for the last 20 years. The commission's further contention that the appellants are not full-time employees but continue only by virtue of interim orders and doesn't advance their case. Even in our case, there is no interim orders. We have been engaged by them, we are continued by them till we reach the age of superannuation. In paragraph 14 also, last paragraph, a few lines below, I'll just press. The approach, last 4 lines, the approach of both the courts in reducing the dispute to a mechanical inquiry about rules and vacancy, while ignoring the core question of arbitrariness in the state's refusal to sanction posts despite perennial need and long service cannot be sustained. A very, very, very strong judgment, Mullah, in my humble submission. Then paragraph 17, if your lordship sees. The appeal was allowed in paragraph 16. Single judge and division bench vote set aside. Before concluding, we think that it necessary to recall that the state, here referring both the union and the state governments, is not a mere market participant, but a constitutional employer. It cannot balance budgets on the backs of those who perform the most basic and recurring public functions. Where work recurs day after day and year after year, the establishment must reflect that reality in its sanctioned strength and engagement practices. The long-term extraction of regular labor under temporary levels corrodes confidence in public administration and offends the promise of equal protection. Financial stringency certainly has a place in public policy, but it is not a talisman that overrides fairness, reason, and the duty to organize work on lawful lines. Moreover, it must necessarily be noted that ad hocism thrives where administration is opaque. The State Department must keep and produce accurate establishment register, master rolls, and outsourcing arrangement, and they must explain with evidence why they prefer precarious engagement over sanctioned posts where work is perennial. If constraint is invoked, the record should show that alternatives were considered, why similarly placed workers were treated differently, and how the chosen course aligns with Article 14, 16, and 21 of the Constitution. Sensitivity to the human consequences of prolonged insecurity is not sentimentality. It is a constitutional discipline that should inform every decision affecting those who keep public offices running. Having regard to the long undisputed service of the appellants, the admitted perennial nature of their duties, and the material indicating vacancies and comparative regulations, we issue the following directions. Retired employees only 3 minutes. Retired employees, Roman 3. At page 20. Any appellant who has already retired shall be granted regularization with effect from 24/4/2002 until the date of superannuation for pay fixation, areas, and under clause. 2, and recalculation of pension, gratuity, and other terminality, revised pension and terminal duty shall be paid within 3 months and all that. So, my lord, after this judgment,
Yes.
It's a very, if I may say with great respect, very timely judgment. Every government your lordship has given, it's not only in state of Assam, everywhere, Maharashtra, Gujarat, Odisha, everywhere. The same mechanism persists. People work for years. At the time of retirement, you don't get the pension. I can't really follow what is the problem. Do you get to know about your financial constraint only at the time of retirement? You are not aware about financial constraints when you borrow from the banks every quarterly thousands of crores and waste it on matters which doesn't really have any priority. These are matters which are available to the citizens. They see it every day in every state. And when it comes to the government servants, in spite of the rules, in spite of the notifications, they say, no, you are not entitled to pension. What is the reason I am not entitled to my pension? You have appointed me. You have opened the book service. You have given me the increments. You have given me the higher scales and taken my service. And you have the cheek to say before the High Court that he is not under the government. How can the court even accept such a contention, Mila? Unthinkable. Therefore, these two judgments which are recently again filed after the judgment is heard, the matter is heard, Miller, I have shown that our single bench judgment, he has relied on the ratio of Uday Pratap, which has been overruled by the subsequent larger bench. Secondly, the other judgment was that the other was
Sunita Burman.
Sunita Burman.
All right.
So, with great respect, Miller, this is absolutely unnecessary for government to do after all the matter is heard fully. And they have given all the judgments, we have given our judgments. It is good that they have given, I have given your lordship the last judgment. Because that Dharam Singh judgment, my lord, with great respect, I submit, my lord, that it's a very timely judgment, long overdue, if I may say so. You have to call spade a spade. No, we have similar orders have been, we have annexed the superannuation letters, we have claimed, but you need not file it now. All are same letters.
How many petitioners are here?
12.
12, only 12. Deeply obliged. None.
So these petitioners were engaged subsequent to 1/4/1993 on work hours basis. Until the date of their retirement, their services were not regularized. Exactly on this point, Lordship, several judgment has been passed by our High Court, both by the learned single judges and the division benches, holding that as your service has not been regularized, you are not entitled to consequential benefits, including pension. That is what binding upon your lordship. What my learned senior colleague is repeatedly arguing.
He has already submitted, Millard, with great respect, Millard, we can't have a hearing of the matter. You have given two
Lordship has
judgments.
heard this, my learned senior colleague, for over 1 hour.
1 hour means I have only dealt with the two judgments.
I
you
am
have
also
given.
only dealing with my submission only and my subsequent judgment only.
Can't go on like this.
Yes.
So basic submission made by my learned senior colleague is that you kindly ignore the judgments passed by the learned single judges, by the division bench, and pass a judgment on the basis which is not exactly similar to the present situation. Lordship, first judgment, Lordship will see Upenda's judgment, Lordship. Paragraph 22, Lordship.
Upenda's was essentially for seeking a prayer for regularization.
Subsequent and consequential benefit. That word, one word I'm harping upon, Lordship. Paragraph 23.
Yeah.
Paragraph 23.
Yes.
For these reasons, we are of the view that the fact situation of the case, master workers, workers, and casual workers are not entitled for regularization of their services with consequential benefits such as pension, etc. So, pension regularization is the precondition of pension.
No, this division bench judgment essentially is on the premise that the appellants before the court wanted regularization.
Yes.
That was rejected.
Yes, and the court said if regularization cannot be granted, then you are not entitled to consequent benefits like pension. Paragraph 23.
Paragraph 23 is not a finding on that pensionary benefits are not available. Paragraph
Lord, kindly
23.
read that sentence.
No, read it.
For these reasons, we are of the view that in the fact situation of the case, master workers, workers, and casual workers are not entitled for regularization of their services with consequential benefits such as pension, etc.
What was the prayer here?
Regularization and consequential benefits.
Regularization and consequential
And court said if regularization cannot be
No,
granted,
that cannot be the meaning inferred from para 23 only. If there is any other finding that without regularization you are not entitled to pension, you point it out.
yes, then I'm coming to another judgment, Lordship. That is 2023 1 SCC 570. This is the latest judgment I furnished on the last date, Lordship. If Lordship comes to paragraph 15 and paragraph 16.
2023. What is the name of the party?
2023. This is Sunita Burman, Lord.
Sunita Burman. Sunita Burman. Huh? No, in the last one. Yes. Yes.
Paragraph 15, Lordship. As for the decision in Prem Singh cited on behalf of the appellant, the question raised in the said matter related to the validity of Rule 38 of the Uttar Pradesh Retirement Benefits Rule 1961 and Regulation 370 of the Civil Services Regulations of Uttar Pradesh. In a backdrop where this court had earlier affirmed the decision of the High Court of Punjab and Haryana in Kesarshan and State of Punjab in relation to perimetry provisions enacted in the State of Punjab, which excluded computation of the period of worker services from qualifying service for grant of pension. A three-judge bench of this court examined several decisions on this aspect and on perusing the note appended to the Rule 38 of the Uttar Pradesh Retirement Benefits Rule 1961 and Regulation 370 of the Civil Services Regulations, held that since the service of the appellant in the said case had been regularized by a vacant post Rule 38 of the UP Retirement Benefits Rule 1961, ought to be read down in respect of services rendered by him even prior to his regularization and the period spent in the capacity of a employee, contingency paid fund employee, or not pensionable establishment employee ought to be counted towards the qualifying service for extending the benefit of pension to such employees. 16. The fact situation in the case in hand is entirely different. The deceased husband of the appellant had remained a work-surge employee till the date of his demise on 26/4/2016. His services has not been regularized. The office order dated relied on by the appellant to urge that the services of the deceased husband of the appellant had been regularized is being misread, as can be discerned from the first para of the said order, which states that the daily wage master worker employees working between 26/7 so and so. So I'm skipping this portion if lordship comes to 17. We therefore hold that the deceased husband of the employee was not a regular employee of the respondent one housing board. He had remained a workers employee in the establishment of the housing board till the date of his demise. Last line, the appellant is therefore not entitled to receive family pension from the respondent one housing board. So that is one judgment. Another judgment I placed lordship Uttar Haryana Bijli Vitaran Nigam.
Wait. This para 16, you'll have to read it because that is the basis on which para 17 was concluded.
Yes, first two line, lordship, his service was her husband was working as a workers employee, and his service had not been regularized till the date of his demise, and that was the ground why his.
Please read further. His services have not been regularized.
Yes.
Office order dated so and so. Relied on. You can read from there.
The office order dated 29/10/1997 relied on by the appellant to urge that the services of the deceased husband of the appellant had been regularized is being misread as can be. So this is the finding, as can be discerned from the first para of the said order, which states that daily wages master employees working between so and named therein were being appointed in workers establishment, and further that the MP work search and contingency paid employees recruitment service rule 1997 was made applicable to them. We have noticed above that the aforesaid rules were never adopted by the respondent number 1 housing board or extended to its work search employees. Being cognizant of the vacuum relating to the service conditions of the employees working in its work search establishment, the board of directors of respondent number 1 housing board had deliberated over the matter and decided on 6/4/2015 to extend the benefit of pension to the said employees by bringing them within the purview of the NPS, and they were given the option of become a member of the said scheme so as to avail the benefit of pension. As a deceased husband had elected not to opt for the scheme, the appellant cannot claim entitlement to payment of the family pension on the demise. So two situations were there. One, pension after regularization, and one, pension by following the procedure of NPS. So his service was not regularized, so he is not entitled to regular pension. And secondly, he is also not entitled to pension under the NPS, as his husband never took membership under the NPS scheme. So two situations.
No, this is essentially rejected on the ground that these rules were never adopted by the housing board.
So that is why he cannot say that his services were regularized. I mean, the NPS scheme was never regularized. That is the second situation. That is why I skipped that portion. That is the second situation. Either under regular scheme or under NPS. He was entitled under none of the situations.
He did not opt.
Next judgment, lordship, I for this.
You have given two judgments only.
Lordship, next, another judgment was there, Lordship. It was State of Bihar versus Bimli Devi.
We don't cite new cases now.
Lordship, paragraphs has already been, it was given earlier, Lordship.
No.
If Lordship comes to paragraph 12. Paragraph 12. Rule 58 of the Bihar Pension Rules 1950 prescribes that services of a government servant will not qualify for pension unless it conforms to the conditions prescribed therein. For ready reference, Rule 58 of the Bihar Pension Rules 1950 is being extracted herein below. Lordship may kindly see, this is exactly similar to Rule 31 of Assam Pension Rules. And if Lordship comes to paragraph 24. Paragraph 24. An identical question has to be dealt with the Supreme Court in case of Uttar Haryana Bijli Vitran Nigam Limited versus Surji Devi report and so and so. Applicability of Rule 3.1.12 of the Punjab Civil Services Rule, which is Perimeteria Rule 58, that is exactly similar to Rule 31 of the Bihar Pension Rules 1950, for all consideration in Uttar Haryana Bijli Vitran Nigam, as is evident from paragraph 10 of the said decision. For the facility of quick reference, paragraph 10 of the said decision is reproduced herein below. I am skipping. 25. Interpreting the said provisions, the scheme for grant of family pension, the Supreme Court held Uttar Haryana Bijli Vitran Nigam Limited that the period during which an employee worked as a workers employee can be taken into consideration only when his services are regularized and he become permanent and not otherwise. In the case before the Supreme Court in Uttar Haryana Bijli Vitran Nigam Limited, family members of a deceased workers employee had claimed family pension, which was denied, holding that the statutory provisions debar grant of family pension in favor of family members of workers employees. Paragraph 16 of the said decision, this is Uttar Haryana, this judgment is before your lordship, is being themed is extracted below. 16. The scheme relating to grant of family pension was made under a statute. A person would be entitled to the benefits thereof, subject to the statutory interdict. From a bare perusal of the provisions contained in Punjab Civil Services Rule Volume 2 vis-a-vis a family pension scheme, it would be evident that the respondent was not entitled to grant of any family pension. The husband of the respondents was not entitled to the grant of any family pension. The husband of the respondents was a workers employee. His services has never been regularized. It may be unfortunate that he had worked for 11 years. He expired before he could get the benefit of regularization scheme, but sentiments and sympathy alone cannot be ground for making a view different from what is permissible in law. If lordship comes to paragraph 27, lordship, another judgment has been cited. Here, lordship will see the difference between a workers employee and a government employee. I'm not reading the entire paragraph. In the case of State of Rajasthan versus Kunji Rahman, the Supreme Court lucidly drew the distinction between the employees of a workers establishment and employees of regular establishment in the following word. A workers establishment, as pointed out by this court in Jaswant Singh versus Union of India, broadly means an establishment of which the expenses, including the wages and allowances of the staff, are chargeable to works. The pay and allowances of employees who are born on a workers establishment are generally shown as a separate subhead of the estimated cost of the work. The workers employees are engaged on a temporary basis and their appointments are made for the execution of a specified work. From the very nature of their employment, their services automatically come to an end on the completion of the works for the sole purpose of which they are employed. Thus, a workers establishment is materially and qualitatively different from a regular establishment. So this is the finding of the Supreme Court.
This could be self-defeating for you.
No, lordship, no, lordship.
Where is the material to show that they were engaged for a particular works and released thereafter or re-engaged thereafter?
No, yes, lordship may kindly say their services were extended from time to time.
No. Nothing.
Time to time.
No,
Yeah,
sir.
then
that temporary extension of time to time is a different issue, and engagement with services are with particular schemes of work is entirely different.
Ultimately, their appointments were work hours.
No, if you are drawing analogy to say that this is work charge and permanency is something else, then you have to justify that these were
But-
employed on
But
X.
Lordship,
particular
basically what
scheme.
I am emphasizing is the distinction between a works hours employee and a government employee.
No, all right, but the case projected here is that their nomenclature is work charged,
Yes.
but the nature of work, the years of service they have rendered has given them
No,
permanent.
I am coming to that point on top. Sole point is whether that notification of 1996 and 2003 is applicable to the petitioner's order. That is the only ground. If Lordship comes to paragraph 31, Lordship,
Yes.
this is the finding, Lordship. We find direct answer to the legal issue involved in the
Para 30,
31, Lordship.
31 of this judgment.
Same judgment.
Oh.
We find direct answer to the legal issue involved in the present appeal in the decision of the Supreme Court in the case of Uttar Haryana Bijli Vitaran Nigam Limited. We accordingly hold that the services of the employees working under works as establishment is not pensionable under the Bihar Pension Rules 1950. Subsequent portion is not required. The family members of such employees will therefore not be entitled to family members. So this rule 58 I'm submitting again. It's exactly similar to rule 31.
Yes.
Now, if Lordship comes to the notification of to 1996 Lordship, this is my repeated submission, Lordship, at page 55.
One minute. এই এক দুই মারা ঢুকা দেখবেন মনে হয় লোক। Yes, page number.
Page 55.
Yes. Yes.
This is OM dated 12 September 1996. The pensionary benefits to the state government pensioners, family pension holders. Subject. In the government of Assam, circular issued under office memorandum number so and so, dated 10/8/63 of Finance AFP Department, a temporary government employee. Lordship, may kindly see this phrase, temporary government employee, who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post to be allowed the pensionary benefits as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriated medical authority. Appropriated medical. The said OM came, type copy, no?
No.
The said OM came into force with effect from 1st of September 1982. The government of Assam is now pleased to clarify that all temporary government employees who have retired from the service under the government of Assam fulfilling the criteria of not less than 20 years continuous service will be eligible for pension from 1st September 1982 onwards. This is, however, subject to the condition that they satisfy all the conditions other than the condition of permanency against permanent post under the government of Assam for usual pensioner benefits under the Assam Services Pension Rule 1969. These benefits not be admissible to any retirees who retires from service with retirement benefits under CPF rules. Now, if Lordship comes to the pension book, pension rule, Lordship, this is chapter 9.
Yes.
Now, Lordship, this is a notification, Lordship.
Chapter?
Chapter 9.
You mean to say section 9?
Chapter 9, Lordship. Section 152.
Chapter
Rule 152.
152.
52.
152.
Now, Lordship, this notification, Lordship, it covers those temporary government employees who continued for at least 20 years of service, but whose services could not be confirmed. Like if Lordship comes to Rule 152, here the topic is temporary government servants. 152, a temporary employee who retires on superannuation or is discharged on account of retirement or is declared invalid for further service will be eligible for a gratuity at the rate of half of the month's pay for each completed years of services, provided that he has completed not less than 5 years continuous service at the time of retirement, discharge, invalidation. If Lordship comes to small Roman 3, no gratuity will be admissible. If Lordship comes to D, to one paid from contingency or one belonging to a works as establishment or any other services governed by separate rules or others. So a work surge employee is not covered by the definition of temporary government servants. So this is one thing. If a works as employee is not covered by the definition of temporary government servant, in that situation, this Office Memorandum of 1996 and the clarification of 2003 is also not applicable to works as employees.
Which was the original one?
Originally space 55.
Oh, 55, 1996.
Yes, and the clarification is 57, page 57, 2003. Now, let me give one example, Lordship, to whom these notifications apply, Lordship. Lordship, in 2005, Lordship, around 30,000 persons, workers and master employees were regularized. They were regularized by creating temporary posts, personal posts against each of the persons, Lord, against the name of each of the persons. I mean, if my service has been regularized, against me, one post has been created. That post is a temporary post. Temporary because that post ceases to exist on my relinquishment of that post.
That becomes a personal post.
Temporary post. Post is temporary.
On what basis are you giving that definition to temporary?
Lordship, a post is a substantive post when the person holding that post, in spite of his relinquishment, post remains. But in case of temporary, post goes.
Temporary post could be in the nature of a particular works undertaken by a works department. That
Maybe
this particular works
for particular works or for a particular purpose. In this case, it was for a particular purpose. My service was regularized against a post, which is temporary because it will remain until I relinquish that post. Once on relinquishment, that post ceases to exist. And if they complete 20 years of service.
Are you are saying that temporary and personal posts are interchangeable?
No, I'm not saying that. In this situation, in case of the master roll workers and workers employees regularized in 2005 or in the year 1995, in their case, temporary post was one which are covered by these two notifications. And that is the Sanjita Rai judgment, Lordship. So this notification applies to them. Their services were regularized, but they are working against temporary posts.
Yes.
Lordship, so far as state of Assam is concerned, Lordship, this concept of temporary post should not be mismatched or understood by following the concept of temporary post that is prevailing in other states, Lordship. In other state, Lordship, for example, in railway, if a person continues for a minimum period of service, Lordship, he acquires the temporary status. But in Assam, Lordship, even for getting a temporary status, Lordship, there has to be a post. There has to be a post. That post is temporary. In the present situation, Lordship, in case of, where is the post, Lordship? Where is the post? Where is the creation? Post creation. In case of regularized master roll workers, in case of regularized workers employees, there are creation of posts, temporarily created, maybe, but posts are there.
Yes.
So that is the submission, Lordship. And so far as that. Subsequently, Lordship, so far as Uday Pratap is concerned,
Yes.
Lordship, in that judgment, the Supreme Court considered the judgment passed by the Supreme Court in the Prem Singh. In the Prem Singh, Lordship, two issues were there. One is regularization and one is counting of the service period prior to regularization.
Yeah.
Lordship, I relied Uday Pratap to show, if Lordship comes to that judgment, Lordship, Uday Pratap, paragraph 23. Paragraph 23.
Uday Pratap.
Yes.
Who has relied on this?
Lordship, I was relying, Lordship.
It is not in your list of books.
It was there, Lordship. It was placed.
What is the citation?
Citation, Lordship, it is 2023 SCC Online SC 527. তুমি দিছিলা না স্যার উদয় পিটা 2023 Lordship, I am furnishing one copy, Lordship. If Lordship comes to paragraph 23.
Yes.
That is the one, referred to by Justice Nair. That
Yes.
is the one which is referred to and relied by the judgment of Justice
Which
Nair
was subsequently overruled.
and subsequently overruled by Supreme Court.
Lordship, if Lordship comes to paragraph 23. Paragraph 23. Now, insofar as the reliance placed upon the decision of this court in the case of Prem Singh, by the learned counsel appearing on behalf of the appellants is concerned, the reliance placed upon the said decision is absolutely misplaced. In the said case, this court has considering the validity of Rule 3(8) of the UP Retirement Benefits Rule 1961, under which the entire service rendered as work service was not to be counted for qualifying service for pension. To that, this court has observed and held that after rendering service as work service for number of years, the government establishment department denying them the benefit, denying them the pension on the ground that they have not completed the qualifying service for pension would be unjust, arbitrary, and illegal. Therefore, this court has observed and held that their services rendered as work service shall be counted for qualifying service. This court has not observed that and held that the entire service rendered as work service shall be counted for the quantum of pension and service. Now, these three lines are important.
This is overruled.
These three lines.
This judgment, this particular finding is overruled.
That finding has been overruled. But Lordship, it comes to the last three line of that paragraph. The decision of this court in the case of...
How can it restrict? This is a two-bench judge.
No.
Two judge. The Prem Singh was three judge.
No, in that situation, Lordship, Sunita Burman is also a three judges bench, Lordship.
Maybe, but we are talking about this particular judgment. This finding
My
has been
point,
overruled.
Lordship, that particular, whether the entire period will be counted or a particular period.
We don't know, but this is overruled. It's not for us.
Overruled, what has been overruled is that proposition, Lordship, whether the entire period is to be counted or a portion of the unregularized period is to be counted. That is not my part.
Overruled is the clarification, is the limit, is what the judgment has been limited to.
No, in Prem Singh, Lordship, court discussed Prem Singh, and in Prem Singh, two issues were there. One is regularization and the other one is counting of the past service. That is the prior to regularization. And in last three lines, Lordship, court say...
What has been overruled effectively is that there is no further clarification for the judgment. What has been rendered is...
Why I am repeatedly submitting, Lordship? Lordship, that judgment is to be read only for the purpose of whether the past service is to be counted or not. Not for any other purpose. Not for any other purpose.
Yes.
Any other purpose means the decision, the dictate at paragraph 36 of the Prem Singh judgment is not to be taken account of. Only the issue that was basically issue in that Prem Singh judgment, that is to be considered. That was the judgment, Lordship. For that purpose only, Lordship, I placed this judgment. Otherwise, counting of past service has no relevance in the present case. It was only for that purpose, Lordship. And learned single judge, Lordship, in Vikas Rai also followed that proposition only. And it was not only in Vikas Rai, Lordship, there are other judgments, Lordship, wherein learned single judge.
Once a Supreme Court renders a judgment, it is binding.
Lordship.
It gets limited, that is also binding. That limited, the limitation is overruled, that is also binding.
So, Judge, I am showing this portion only because my learned senior colleague is repeatedly saying that the judgment, that judgment has been. Lordship, what has been overruled is the proposition as to which portion of the service prior to regularization is to be calculated. Lordship,
that is your argument, but subject to correction, what has been overruled is what was sought to be clarified.
then if Lordship comes to the judgment of Jaggu, Lordship.
Is this state of Manipur is relied by someone?
No. Yes, Lordship, I relied, Lordship.
No.
State of Manipur was a judgment, Lordship, wherein it's a 2007 judgment, I think.
96 judgment. No. It was 96, I think. 1996. Don't know from where it ended up. Anyways. Yes.
Then if coming to the Jaggu judgment, Lordship,
that was heavily relied upon Jaggu and Dharam Singh Lordship. If Lordship comes to paragraph 21. Paragraph 21, Lord. Lordship, in fact, Lordship, neither of these judgments, Lordship, that applies to those whose services were illegal at the inception, Lordship. All this judgment applies to those whose appointments were irregular, not illegal. If Lordship comes to paragraph 21.
Jaggu judgment, who has relied? You have relied.
Yes, Lordship.
You have relied.
Yes, sir.
No, it's not there in your list. You have relied on Sripal,
yes.
Triple, yes, you are right.
but Jaggu, I don't find it.
Jaggu has been mentioned in Dharam Singh also, Your Lordship.
The mention is all right. Are you relying on the judgment or not?
No, we have not relied. I don't know. I don't remember.
It's not there in the list, therefore we have.
Jaggu, Binod Kumar, Dharam Singh. Lordship, if Lordship comes to paragraph 21 of this judgment, Lordship.
Which judgment?
Jaggu judgment.
We'll have to find out first.
Copy 9.
List upon the again. Huh? List upon the other. He is a judgment side code.
What is the citation?
This is Lordship 2024 SCC online SC 3826.
Yes.
Paragraph 21, Lordship. Lordship, may I kindly see, Lordship will find the basis of the judgment, Lordship, paragraph 21. The High Court placed undue emphasis on the initial level of the appellant's engagement and the outsourcing decision taken after their dismissal. Court must look beyond the surface levels and consider the realities of employment. Continuous long-term service, indispensable duties, and absence of any mala fide or illegalities in their appointments. So this is the situation when courts will take consideration of their continuous long-term service, indispensable duties, etc. only when their initial appointments are not marked by mala fide or illegalities. That is Jaggu. And if Lordship comes to Dharam Singh Lordship,
But is it anybody's case that their appointments were illegal?
No.
yes, that is their Lordship. That is why their services could not be regularized.
No.
2013 notification is there.
Which notification?
2013. Why their services could not be regularized?
I'm sorry, Milord. He has been making a new case. This is your government affidavit. Kindly see.
Where have you mentioned it?
No, that their ground is that in spite of long duration service, government failed to regularize their service. That is their.
We have not said.
No, where is your case that they, notwithstanding their long services, etc., it could not be regularized because their initial appointments were irregular or illegal?
No, irregular or illegal, that is Umadevi I am relying, Lordship.
No, but there has to be a finding by the department that it is illegal or irregular.
Lordship,
there is a categorical averment that their selection.
Lordship, in 2012, Lordship, we issued one notification holding that henceforth there will be no regularization of master and works.
That's a different issue.
Lordship.
That's a different issue that you have taken a policy decision, no regularization, no pension, no compassionate appointment, whatever.
That is upheld by the division bench in Upendas.
That is all right.
Thereafter, Lordship, in 2013, we issued another notification under which, Lordship,
we considered all services of all the master roll and regularized works or employees, Lordship, who fulfills the conditions of paragraph 53 of Uma Devi judgment.
Where is that notification? That you have not pleaded here.
And only the Lordship, those who fulfills the conditions, their services have been
It
regularized.
has not been pleaded. It's not your pleaded case.
But that is the known, well-known situation, Lordship. That is the offender's judgment.
We are hearing a list. We are in the middle of deciding a list. There are claims made. You are responding to these claims. Your claims must be specific.
Yeah, Lord, I accept Lordship. But in that situation also, Lordship will at least inquire whether their services are regular or irregular.
Unless
Lordship, so far as reliance upon this judgment.
Unless you raise a claim, counterclaim, to say that their initial appointments are irregular. Where is that ever meant?
I'm
Not
saying
every
illegal.
time.
I'm saying illegal.
No, illegal, but where is it? Show us from your affidavit. Where
Now,
have you
if
stated?
Lordship comes to these judgments also.
No, judgments are different. Judgments don't give finding on the facts of this case. Otherwise, where is the necessity for us to go for such an elongated hearing?
But even then, Lordship will not keep your Lordship eyes shut, Lordship. Lordship, if it is not applies to illegal
kept our
appointment.
eyes and minds open, but we can't find anything. We are inviting you to show us. You are not doing it.
Lordship, those who were irregular, Lordship.
But where is that ever meant that they are irregular? It's not an omnibus thing. That
Lordship,
those who are irregular, we know that is what Umar Devi said. But for the department to come to a finding, merely because the judgment of the Supreme Court has said something, you cannot use this as a shield or as a barrier to allow or identify the claims of the employees. There must be individual finding. At least in this group of petitioners, there is no such finding that their appointments were irregular. We don't find it in your averment.
Affidavit can show. If
You
Lordship,
are entitled to make an inquiry, no doubt about it.
like if Lordship comes to Dharam Singh, Lordship. Now, Dharam Singh is not a case, Lordship, where regularization is to be done or regularization is to be denied. Dharam Singh is a case, Lordship. One authority decided to regularize and wrote a letter to the authority for creation of post. And that was denied by the higher authority. And against that denial, Lordship, this case was filed, preferred. So this is not a case, Lordship, where regularization is to be considered or not.
All right.
And even in this judgment, Lordship, if Lordship comes to paragraph 1, Lordship,
Which judgment?
Dharam Singh,
Ah.
first paragraph.
Yes.
If Lordship comes to the 5th line, paragraph 1, the controversy before us is not about rewarding irregular appointment. The court was not even discussing the illegal appointments.
That's right. But is it your case that their appointments are irregular? No.
No.
You never raised this claim. All right.
Lordship, last submission, Lordship. In similar circumstances, 2 judgments, Lordship, 3 judgments were placed, Lordship. One is Gita Burman, that is, one is Vikas Ray, Lordship, and one is Ujala Burman. Exactly similar circumstances, Lordship.
All right. Yes, heard reserved.
Only one thing, my lord, he was referring to Prem Singh. Your lordship should recall.
But Prem Singh is not part of your list.
No, I have relied. I have
So it is
relied.
not in the list that you have given us.
What?
List of books.
No, it must be because I relied on this judgment, my lord. In Prem Singh.
What is the serial number?
Serial number 1, 2019-10.
In the list of books you have given 11 cases.
How can you not give? Because this is. No, I think you have given. Just check.
Yes, your lordship, serial number 1.
Oh, one, okay, all right.
I
All right.
was surprised.
Sorry, my bad.
No, it's all right. My lord, Prem Singh, there are we relied on Prem-Singh not because of anything, but there are two categories of workers.
Yes.
One who were regularized and the one group which was not regularized. And Prem-Singh has referred to that aspect at paragraph 30 at page 540. And work charge, he is saying about work charge employee, if you keep on the service of the person concerned, irrespective of the work, then the level doesn't carry the meaning which is normally attached to work charge. That is mentioned at paragraph 30 at page 540.
Yes.
Your Lordship may just see that, that's all. And your Lordships will find that so far the operative part is concerned, paragraph 36 at the bottom middle, page 542. Those who are not regularized, because under that, their rule, regularization was a need. In our rule, there is no need for any regularization. That's the difference. We are going by our rules, not by any other state's rule. But even where it is required, and it was not done, that means regularization was not done, at page 542, in these facts of the case, the services of the in the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct their services be treated as a regular one. I relied on this case only for this purpose, that even in a rule which required regularization, but regularization was not done, the court said that from the facts, it appears that it was treated as a regular employee. Therefore, a declaration was given that they are also entitled to the pension. That's the difference. Secondly, my lord, so far as this 152 service fundamental rules, pension rules, I'm sorry, rule 152, that relates to, my lord, gratuity. We are not concerned with gratuity here. And pensionary benefit exists, and that is mentioned at the bottom of this. In fact, these two notifications, this is the only book which has reproduced these two notifications. Otherwise, you will not find this in many of the compilations.
Which one?
This at page 189, my learned friend was relying on 152. The 152 is a provision for gratuity. We are not concerned with gratuity here. But it has been pointed out in the comment section that so far pensionary benefit is concerned, there are two notifications. And they are referring to this first notification and second notification, which we have produced at page 55 and 57.
It's more than 120 years of service, continuous service.
Pensionary benefit is also admissible to government servants rendering 20 years of continuous service without being confirmed in service. And they are referring to the first notification 6/9/2003 and next page, Milord, 6 September 2003.
Okay.
So, and your lordships know, my lord, and it has been pointed out in these cases, even in the Dharampal case, my lord, Dharam Singh case, that in every government service, my lord, there are temporary and permanent servants. And the irony of temporary service and confirmation and substantive confirmation, Justice Iyer has put it very beautifully, my lord. A district judge becoming a high court judge and gets confirmation, and after that he is confirmed as district judge.
Uncertainties.
So it is the glorious uncertainty of a government servant. And my lord, so far as this case is concerned, at least, they have not raised the objection that this is an illegal appointment. So all this is absolutely irrelevant. And this new case Dharam Singh, because it has broken new grounds. The way it has put the matter in human terms, if I may say so, is not exemplary. Because this is a problem which government servants have been experiencing in all the states in India. And it is good that the Supreme Court has finally taken cognizance of that situation. There were tiny observations here and there, but they have now absolutely made it clear that this is no way to run a government. For years together, they will be working, and finally at the time of retirement, you say that, okay, now you are not regular, therefore we don't give you the pension. That will be absolutely arbitrary, and so the notifications are not disowned. In their own affidavit, they have referred. There is no question of any illegality in this case. And therefore, the only question is that if you have served for 20 years, your notifications entitle us to get the pension, you can't arbitrarily deny us that. That's the substance of the whole case. And there is no need for any regulation so far as this case is concerned, because that has been specifically mentioned in the OM, that a temporary without regulation also will get. Only moot point they say is the 20 years service.
Yes.
I think.
Or just one, I'm not even submitting, Lordship. Lordship will have a look at Rule 9 of the pension rules, Lordship. They are saying they are not concerned with gratuity. Rule 9.
No, I am saying not concerned with the gratuity because the pension is differently dealt with. That's why I am saying, not otherwise.
Yes.
2 lines. Lordship, may kindly say that.
Rule 9.
Yes.
Pension, yes.
Pension. Except when the term pension is used in contradiction to gratuity. Pension includes gratuity and death-cum retirement gratuity.
Doesn't matter. We are concerned with pension in this case, not gratuity.
You have received what? Gratuity? Have you received gratuity?
I don't. We don't know. If they are entitled, they must have got it. I don't know. There is nothing, no controversy on gratuity before your lordship.
Hard reserved.
Deeply obliged.
Yes.
Pending item 15.
This matter.
Yes.
As per order dated 17/3/2025, your lordship directed the petitioner to apprise about the challenge made to the office memorandum regarding compassionate appointment. And the Honorable Court has already directed the authority to consider all the pending cases. And my grievance is that the SLC has rejected my case due to non-availability of vacant post. But as per the office memorandum, as per clause 15, they are required to consider against any available vacancy under any other department.
Lordship, SLC rejected on 2017, Lordship. They approached before the court on 2024, Lordship, after a gap of 6 years, Lordship. And Lordship, in the OM dated 1/6/2015, Lordship, it is clearly stated that
No, some challenge is made to the notification.
Lordship,
In some
not
repetition.
challenge the notification, Lordship, after after the rejection of this, Lordship, new notification was came, Lordship, on 18/9/24, Lordship. In the OM dated 1/6/2015, Lordship, it is clearly stated that if the applicants of the eligible candidates remain pending and cannot be considered due to want of vacancies and rejected of 2 years, and from the date of making such applications will require to no further consideration and must be understood to have spent their force, Lordship. It was pending, Lordship, in 2017, Lordship, it was rejected. Approach before the court, Lordship, on 2024, Lordship.
The first that they raised the same question, my lord, therefore directed the authority to consider to file their affidavit on 2-3 occasions. They were directed to file affidavit.
Affidavit is, in my knowledge, is not necessary, Lordship. And after that new notification was came, Lordship.
Notification is out, so unless you challenge that notification,
Lordship.
you are covered by the notification.
Well, since my writ petition has been filed prior to issuance of the OM, the writ petition was pending. And
Prior to the notification.
yes, 2023 notification was issued on 18/9/2020. And page 26, this is the OM, 18/11/2017. Well, page 28, serial number 1, Prabhat Bora, he has also approached before this honorable court challenging the same.
What has happened?
My lord, challenge the same, my lord, minus, my lord, and this honorable court by order dated 16/2024 directed the authorities to consider the case of that.
Where is that order? Why are you keeping it close to yourself? You are supposed to apprise the court.
Yes.
You give him a copy also.
I will give him. The same, my lord, paragraph 4, as per OM dated. Same SLC minutes at serial number 2, page 28. My name is at page serial number 4.
No, but there is no discussion of the OM, subsequent OM.
Because
What has happened after that?
prior to that, my lord, in respect of Prabhat Bora.
What happened?
Lordship, it covered case of Debabrata Tiwari, Lordship, and died in 2014, Lordship. 2017 SLC rejected, Lordship. After that, Debabrata Tiwari case was came, Lordship. And it is clearly stated that Lordship, para 7.5, Lordship. Delay and several years, Lordship. Either in applicant petitioner side or the respondent side, Lordship.
That issue has been decided by this honorable court, my lord, in the batch of writ petition.
That OM, Lordship, 18/9/2024, Lordship, it is still in force, Lordship.
Where is the minutes?
My lord, minutes is page 26. My name is page 28. Page 27.
Serial number?
My lord, serial number 4. Mohidul Hussain, and serial number 2, that Prabhat Bora judgment.
Where is the DLC?
My lord, DLC, my lord, page. This is the format, my lord, page 19. Type code, serial number 15. Type copy. Original copy, page 22. Total 5 numbers of proposals were received from the Assistant Director of Sericulture. 3 proposals for the post of so. Mohidul Hussain has 4 dependents with fewer landed properties than the other 2 applicants.
So as my submission is Lordship, on OM dated 18/9/24 Lordship, this, it has been still in force Lordship. It is not by overruled by that judgment of the Abdul Kadir Lordship. And subsequently, new executive order was released Lordship on 30 August 2025 Lordship.
In terms of the executive order, what was there?
There is a Lordship. If the Lordship order.
To submit their particulars within 15 September 2025 with the order passed by this honorable court. Since as per clause 11, we have to submit the honorable court's order. Since my petition was pending, it was not possible to furnish the document along with my particulars. Only consider, my lord, in terms of existing guidelines, my lord, and in terms of that honorable court's order in
That-
any other department.
That,
They will, if I am not eligible, they will reject, my lord. Only they will consider by the SLC.
so that is not possible Lordship.
Where
That
is that guideline of 1/6/2015?
Lordship guidelines.
Guidelines.
1/6/2015 was.
Plus 15 may be one, I think, plus 15.
Plus 15.
No, no,
1/6/15.
No, no, clause 15.
Plus 15 is 7. If sufficient vacancies are not available, Lordship, in any particular office to accommodate the persons in the waiting list for compassionate appointment, it is open to the administrative department officers to the government or to provide at the earlier appointment on compassionate ground to those at the waiting list, Lordship. In this OM, Lordship, there is a para, Lordship. In principle 10 Lordship, it is stated that if the applications of eligible candidate remain pending Lordship, there is a 2 years cannot be considered due to want of vacancies from the date of making such application will require to no further consideration, and it must understood to have spent their force Lordship.
My case has already been considered by the DLC. DLC recommended.
SLC rejected.
considered,
He has come before the court
SLC has
on rejection of the SLC.
a wrong down, my lord.
He came before the court on the rejection of SLC Lordship.
Yes, I am.
And
challenging the
it is a spend their force Lordship. It is a rejected on 2017 Lordship.
That's all right, but we want to know one thing. The 2015 DLC recommended against 3 vacancies,
Lordship.
3 names. 2017, you say no vacancy.
No vacancy.
What happened to that?
The 5% quota is not full.
That 5%, was it wrongly calculated by DLC? Or how can it be filled up?
That 5% was already
Assistant
filled up.
Director,
Lordship.
Sericulture, Sibsagar.
I think Lordship that 5% quota was fulfilled. Lordship.
Your or my thinking will not help. The records will have to speak. See, 27, come to page number 20. 27th April 2015.
22.
27th April 2015 is the DLC
Notice 15,
finding,
clause number 15.
DLC meeting. Page number 20.
20, Lordship.
Have you found out in the beginning, minutes of the meeting?
Lordship, what, Lordship?
27 April 2015,
No, Lordship,
right?
Lordship.
So you come to page number 22, serial number 15.
Lordship, Lordship,
So there are 3 vacancies for 14-15.
Lordship,
And petitioner Mohibul Haq is one of them, recommended.
Lordship.
Then you come to the SLC minutes, which is on 11/8/17. And they say that these cannot be
This could not,
recommended due to non-availability. Now, DLC recommended on the basis of making necessary inquiries, finding out vacancies. SLC said non-availability. On what basis? Is it on the basis of miscalculation by DLC? Is it on the basis that no, earlier there was another SLC where similar names were considered and vacancies filled up?
Lordship.
What happened? Because that post will have to be earmarked 5%. That 5% vacancies ought to be known by the DLC.
Exactly. At this stage, Lordship, the new OM is still in force, Lordship.
No,
I understand, Lordship.
you
That
OM
was
all right,
that
but if
was-
somebody
that
had
was
a
done.
right which was accrued,
Lordship.
supposing it was wrongly mentioned that no, there was a vacancy, he could not be filled up. But we want to know, we are not saying that SLC is incorrect. We are just pointing out that DLC has recommended against one vacancy 1450. SLC says there is no vacancy in this grade 4, grade 3. What happened to that post?
Lordship.
Was it wrongly ascertained by the DLC?
Then Lordship, it is.
And these
better-
vacancies are yearly vacancies. Can you get this information?
Lordship will collect that information, Lordship. After 2 weeks, Lordship.
Third council for parties, the belief of the petitioner is that the DLC by its meeting minutes of meeting held on 27th of April 2015 recommended names of 3 persons, including the petitioner, for filling up posts in the vacancies available in the post of junior assistant under the Assistant Director of Sericulture Sibsagar for the year 2014-15. Stop. The state level committee, however, by its minutes held on, by the meeting held on 11/8/2017, rejected the claim of the writ petitioner on the ground that he could not be recommended for appointment due to non-availability of posts on compassionate ground. Stop. Where no affidavit has been filed by the department. Stop. From the minutes of the SLC, it is not discernible as to how the vacancies for the for compassionate earmarked for compassionate appointment for the year 2014-15 were filled up under the Assistant Directorate of Sericulture, Sibsagar. Stop. The recommendation by the DLC was on the basis of vacancies available and earmarked for compassionate appointment. Stop. However, the minutes of the SLC does not reflect as to how the vacancies found available by the DLC for the year 2014-15 to be filled up by compassionate appointment in respect of the vacancies available under the Office of the Assistant Directorate of Sericulture, Sibsagar, came to be filled up. Sorry, under the Directorate of Sericulture, came to be filled up, or whether the vacancies were wrongly interpreted to be vacancies available for compassionate appointment by the DLC. Stop. Or let these instructions be placed before the court by the respondent authorities of the next week fixed. List again on list after 3 weeks.
Not. Madam, if possible, that.
Date. 21st November.
Published, Lordship.
Item 17.
This will dictate in the second half.
Yes.
Will dictate orders in the second half.
Yeah.
Will you? Yes.
Item 17.
ऐसा तो नहीं 56 नहीं बता सकता अपना हिल टेक
Yes.
ऐसा ठीक है छोटा बोले से দুনিয়ার ভাব দুনিয়ার ভাব
What was your date of birth in the records?
Earlier it was recorded 28/12/56, my lord. But actual date of birth, my lord, as it is evident, I have annexed here, my lord, in the Aadhaar code also, my lord, 28/7/1966. Annex are 8/26.
And this official date of birth you came
Yes,
to?
my lord, that is 28/12/56.
So you came to know that it was a wrong date. When?
My lord, we have already, my lord, in the year 2005, my lord, because at the time of regulation of service, all papers were submitted, my lord. Because at that relevant point of time, he has submitted and accepted, and I card also issued, my lord. But subsequently, my lord, first letter they have issued, my lord, Annexure 5, page 23, my lord. Counting the date of birth from the 1956.
Where is your ID card?
ID card, my lord, I have annex here. Annexure 7, page 25. PAN card. It is PAN card. And next Aadhaar card. And third one is my lord, I card. Page 27, I card. And in inquiry also it is found, my lord.
Where is the inquiry report?
Inquiry report, my lord, they have annexed here, my lord. Affidavit opposition filed by the, my lord, respondent number 3, page, my lord, 42.
Is
Page 42.
42.
Yes, my lord. They have mentioned here, my lord, may I read, my lord. 1/10/2020, the undersigned held a meeting with Pratul Chandra Das so and C so, wherein they furnished the following facts with the record after through scrutiny. Copy of the service book, letter issued under secretary to the Government of Assam Public Works Department, Audit Branch, number dated so, 30 September 2005. School certificate of Sri Bolen Boro, where his date of birth has been recorded on 31/12/56. There have been sterling facts produced before the undersigned with the following informations. School certificate Sri Bolenboro, where his date of birth has been recorded 31/12/1966, issued by Headmaster Kayakushi Milan School so on 27/5/2020. PAN card of Sri Bolenboro, where his date of birth has been recorded 31/12/66, issued by the Income Tax Department so. I card is of Sri Bolenboro, where his date of birth has been recorded 31/12/66, issued by the Assistant Executive Engineer PWD Patsala Railroad Division Subdivision on 16/12/2005, and Assistant Executive Engineer PWD TR Subdivision 16/6/2020. That means in 2005 itself, my lord, that I card was issued, my lord, on the basis of the said certificate, my lord.
No, in the service record, your date was 56.
56, my lord. But at the time of regulation of service, my lord, it was incorporated, my lord. But otherwise, my lord, all our original copies, it is evident that his date of birth 66. And accordingly, my lord, as no notices were served upon the petitioner in the year 2016, my lord, he continued, my lord. He is under impression that he will be retired in the year, my lord, 2026, my lord.
No, you retired, when was your last salary given?
Last year, July 2020.
And you
Thereafter, August onwards, my lord, it is stopped.
stopped and you are still working.
No, my lord, nothing. Without any, my lord, working there, my lord, and even nothing receiving, my lord. Either pension or salary, my lord.
No, then why in 24 you have come to the court?
Because, my lord, he was, my lord, he has approached, my lord, and he under impression that he will be, my lord, I have challenged the order, my lord. Order of the said letter, whereby he was directed to
Where
appear
is
before.
where is your original appointment order? Appointment order?
Appointment, it is, I have annexed here, my lord, from regulation onwards, my lord. Appointment letter. Regulation on Annexure 2, my lord.
Annexure 2.
Yes, my lord. Page 19, original, my lord, copy is page 18 onwards.
No,
His name.
Annexure 1 is your appointment order.
Yes, my lord. Appointment letter. 19 July 95, 85.
If it is counted, my lord, 85, he joined service and date of birth is 66. He joined his service in the year at the age of 19, my lord. And if it is counted, my lord, 56 and joined his service 85, it is 29. So obviously it will be, my lord, 19 years at the relevant point of time, as he was a masteral employee, my lord.
How is it obvious that you'll be 19 years?
No, that's my lord, I have presumed, my lord, because my lord, 85 years.
Presumption is all right.
Yes.
And then what is there in page number 18?
Page number 18, my lord, that is regulation of his service. And his name reflected as page number 19, my lord, original copy, at serial number 53. Bolen
53.
Yes, my lord. It is mentioned his date of birth, my lord, date of joining.
This inquiry report was not served on you.
No, my lord, they have annexed here.
You were not served with a
No,
copy?
no, my lord, nothing. And my lord, they projected, my lord, they have mentioned recommendation was there, my lord, to take action against the petitioner and the, my lord, the person concerned who has committed that, my lord, mistake at the relevant point of time, my lord. They one Manavendason, but they have taken action against the said office bearer, my lord. They have filed additional affidavit also, my lord, an additional affidavit where this, my lord, sanction is there, my lord. Censured.
Now the respondents are seeking recovery.
Yes, my lord, that is why, my
You're
lord.
seeking recovery.
Yes, my lord.
Not seen any such order, Lord. And that is not a subject matter of the petition also, Lord.
Now, if you continue, according to you, what is your age for retirement?
According to me, 66, my lord, 26 it will be. I'm accepting, my lord, 56 also, my lord, because at the relevant point of as it was recorded, I have seen the judgment, my lord. That is why, my lord, I need only money, my lord, monthly pension or, my lord, anything, my lord.
What money?
Money, in this sense, my lord, he has to survive, my lord, because, my lord, already he has received salary, my lord, up to, my lord, July 2020. But it is evident from the record, my lord, 56 was recorded, rightly or wrongly, my lord, whatever may be. But I have seen the judgment, my lord, of our bench judgment, my lord.
Which judgment?
This judgment, my lord, first one is, my lord, 21-5 GLT 61. Here, notional benefit, that period was there, my lord. I want to read this relevant paragraph, my lord.
No, before that, let us be clear on your claims. What do you want? You want setting aside of Annexure 5. What is Annexure 5?
At the relevant point of time, I received that notice only, my lord. That is why, my lord.
All right. And then you want
Then
reinstatement.
yes, my lord.
No, but now if you accept 56.
Yes, my lord.
Then you are supposed to retire in 2016.
16, my lord.
Ah.
So, my lord, excluding that period, my lord, up to July 2020, from the period, my August onwards, I am entitled for retirement and pensionary
Yes,
benefit.
Mr. Nayok.
But judgment shows that, my lord, all judgment, our code.
He was regularized. There is no
Yes, regular.
dispute with regard to his regularization.
If lordship comes to page 39 of my affidavit, lordship. 38.
38.
Yes, affidavit, lord.
Yes.
Lordship may kindly see his service book.
56. He has accepted now 56.
Then
He
he
has
has admitted that he has overstayed.
He has accepted 56.
So he has admitted.
So you deduct whatever is there and release the pension.
No, no, my lord, deduction, I am recovery, my lord, I am not, my lord.
If
Because
lordship,
of a debt was
lordship
of
comes
their
to the
party.
prayer.
No misrepresentation from my lord, from my side.
Lordship will say, what is the prayer, lord? Lordship will say.
Prayer is reinstatement.
Reinstatement at the relevant point of time, I
He
just
say,
received
correct
the
my date
letter.
of birth as per his certificates, lordship. Lordship, what I am submitting, service book.
I am
it is
fairly
56.
submitting, my lord, only because otherwise, my lord, law point is.
No. You see, you have to be clear on what you want to submit.
Yes, ma'am.
There are two dates of birth.
Yes,
One
ma'am.
is recorded in the service book.
Yes, my lord.
The department has gone as per that. They have conducted an inquiry.
Yes.
Copy of which has been served in the affidavit.
Yes, my lord.
This is not under challenge.
Not challenge, my lord.
So therefore, your date of birth is 10 years later.
Yes, my lord. Right.
So on that basis, on that premise, you had approached this court, calling as seeking interference with that and reinstating you in
Yes, my lord. Up to 26.
up to 26.
Yes, my lord. That was my prayer, my lord.
That you have now abandoned.
No, because I am amending, because, my lord, here I have seen the several judgment, my lord.
Now you are accepting 56.
56, my lord. So
Now,
recovery
if you are accepting 56,
yes, my lord.
that means your other argument that you were 66 and that was wrongly recorded, everything has to be
No.
overlooked.
No, my lord. What has happened, my lord? 66, in spite of 66, my date of birth, my lord, I have already seen several judgment, my lord, recent judgment. I have seen, my lord, in spite of 66, suppose, my lord, in a similar case, my lord.
It's not supposed.
All papers, my
It
lord.
is not suppose. There has to be a finding whether it is 56 or 66.
66, my lord.
Right.
I
So
made
if you stick to 66,
66, my lord.
then you'll have to explain what you want to do about this inquiry which is there. There is an inquiry where they have categorical finding that this was due to manipulation.
Yes, my lord.
This is not under challenge now.
Not challenge, my lord. Because at the relevant point, it was not served upon me, my lord.
Now, according to the department and according to you also,
yes, my lord.
You do not disown your service book.
Yes, my lord.
Your service book reflects 56.
Yes, my lord. But 66 also admitted.
Huh?
That was, my lord, they have issued I-card also, my lord. All I-card, PAN card, voter ID.
No,
Aadhaar card.
PAN card, voter ID are not issued by the department.
And
I-card is issued.
Issued,
But I-card is issued. Will it give you a right to override the service book or any other or the inquiry findings vis-a-vis the inquiry findings and the service book? What substance will an I-card hold?
He is going to retire in the year 2026, my lord.
That is not the finding of the inquiry. You have to challenge the inquiry now.
And action also taken.
There is no scope to remand the matter back to re-inquire into the matter unless you put into challenge this inquiry.
Yes, my lord. The lordship is correct, my lord.
And if you accept 56, then you have to abandon 66.
On the basis of the papers, my lord, I have seen the judgment and settled law opposition, my lord.
So if it is settled law,
Yes, my
then
lord.
if you accept
Recovery order set aside, my lord. Similar employees, such type of cases, my lord. Recovery set aside, and it was calculated on the basis of 56. Same 56 and 66 is mentioned here in the judgment itself, my lord. Same time, similar incident, my lord.
Judgment?
My lord, that 56, that is, my lord.
Upamoy.
Yes, my lord,
Sukhumai I find.
Huh?
no,
Which is the judgment?
yes, my lord, this judgment, my lord, I want to place my lord here. It's my lord, 21-5 GLT 61.
What is the name of the party?
Party name, my lord, Jagadish Kumar Deka and others versus State of Assam.
Yes. Hmm. Which paragraph?
Yes, my lord, paragraph, my lord, that is, my lord, relevant portion, paragraph, my lord, 28, 20, my lord, 20.
20.
Findings. Merit. Thus, considering the facts and circumstances of the law laid down by the Honorable Supreme Court.
Para 20 doesn't begin with thus. Hmm. Oh, para 20, okay. Last page.
Yes, my lord, last.
Yes.
It was on the basis of the paragraph 28 and 26. So, my lord, I want to read first 28 of this Honorable Apex Court judgment, my lord. It was, my lord, recorded here. My lord. Before parting with the order, we may refer to the decision of the court strongly relied on by the learned counsel for the appellant, namely Radha Krishnan versus Union of India. Learned counsel for the appellant, relying on the decision, sought to argue that
So that is what we are saying, that in view of the inquiry, how can you say you are not faulted? They found fault with you, that you have manipulated and overstayed.
No, my lord, here 47, my lord, it is mentioned, my lord, specifically mentioned, thus considering the facts and circumstances and law laid down by the Honorable Court, this court is of the opinion that petitioner cannot be faulted with in the chain of event which laid down overstay in service for the reasons cited in paragraph 18 above. As a consequence thereof, the impugned action in purporting to recover the salaries for the petitioner period of overstay, the details of which is already recorded in the judgment, is interfered with and accordingly set aside. As regards the claim of the pension, by following the guidelines of the Honorable Supreme Court in the case of Pandey Jagadishwar Prasad, petitioner would be entitled to fixation of retirement benefits as on the date of their correct date of birth, with a further clause that for the period of overstay only, the notional benefit would be entitled to the petitioner's entitlement for salaries for the said period has been upheld. It was, my lord, followed by, my lord, the judgment of the Honorable Apex Court, my lord, Jagadishwar Pandey, Jagadishwar Prasad Pandey, my lord. Here also, my lord, it is the facts of the case 2009-3 SCC, my lord, 117. Just brief facts of the case I am reading, my lord. Respondent date of birth accordingly to
You're reading from where?
To my lord, I am reading here, my lord, paragraph 7, my lord.
Read from para 6.
Yes, my lord. Before we consider the question raised before us in the support of the appeal, let us narrate the relevant facts. Yes, my lord. The respondent at the relevant point of time was working as a correspondence clerk, grade class 3, in the office of the executive engineer, Rural Engineering Organization Works Division, Sasaramshansok, Bihar. On 14/8/1973, the service book of the respondent was opened and two dates of birth of the respondent number 11/2/1944 and 11/2/46 were recorded simultaneously in his service book. It may be mentioned here that in spite of two dates of birth having been entered into service book of the respondent, the state authorities did not correct or delete any of the dates mentioned above for the entire period of respondent was in employment with the state authorities. According to the first mentioned date of birth, the respondent ought to have retired on 28/2/2002. but he retired 29/2/2004. According to the other mentioned date of birth in his service book, as noted herein above, earlier on 4/12/2004, a reason order was passed by memo number so-and-so on 11/10/2004, passed in so-and-so, in which respondent claimed for payment of retirement benefit such as pension, gratuity, leave encashment, etc. But here, my lord, in this case, my lord, paragraph 28, I want to read, my lord. Paragraph relevant, my lord. Before parting with this order, we may refer to decision of this court strongly relied by the learned counsel for the appellant, namely Radhakrishnan versus Union of India. Learned counsel for the appellant, relying on the decision, sought to argue that even if the respondent had worked after his due date of superannuation without having any objection from the appellant was entitled to deduct the amount already received by the respondent from his retirement benefits. This case, in our view, is clearly distinguishable from the present case. Radhakrishnan case, there was no dispute as to the date of retirement of the appellant in that appeal, as there was no controversy in the date of birth of the appellant. There was only one date of birth mentioned, and he had not retired on the basis of the date of birth so entered. Therefore, he had wrongly extended his service beyond the date of superannuation. But in the present case, there were two dates of birth recorded in the service book of the respondent. Therefore, there was a clear confusion in the mind of the respondent as to whether the appellant had accepted his corrected date of birth as entered in the service book, when admittedly the authorities concerned did not serve any notice of retirement on the basis of the initial entry of the date of birth in his service book. It should also be kept in mind, next paragraph, that the respondent might have expected that the second date of birth shown in the service book was accepted by the authorities. For that reason, he was allowed to continue in his service and he was paid salary. In the absence of any proof that the respondent had manipulated his date of birth by entering a second date at a later stage, and that he had malified intention to continue his service beyond his date of retirement, we are in the view that the decision of Radhakrishnan versus so-and-so would not be applicable in the facts of the present case. There is another aspect in the matter. Although we have directed the excess amount paid for 2 years to the respondent as salary cannot be recovered from the respondent, but we make it clear that for fixing the retirement benefits, the period of 2 years in respect of which salary was received by the respondent cannot be taken into consideration, and the respondent would be entitled to fixation of retirement benefit as on the date of his superannuation 28/2/2002. Accordingly, we do not find it necessary to interfere with the order of the division bench of the High Court in the peculiar facts and circumstances of the case in exercise of power 156. So almost similar, my lord. Here, my lord, another, my lord, judgment, my lord. This recent judgment, my lord, to 23, party's name, Sharmila Roy Das versus versus, my lord, State of Assam. Here, my lord, I want to just read the facts of the case, just read facts, my lord. In the facts, 23-0 as Supreme.
Yes.
Yes, my lord. The brief facts of the case. Instant case is the petitioner, paragraph 3, my lord. Instant case is the petitioner herein was appointed as an assistant professor in the Department of English by an order dated 26/12/88 on the basis of the selection made by the authorities pursuant to an advertisement. At the time of joining, petitioner submitted her date of admit card issued by the board secretary education Assam, showing her date of birth as on 1/3/78 as 16 years 4 months 27 days. During the course of the hearing, original book was these are not relevant, my lord. Relevant portion, my lord. Again, I am reading paragraph 19, my lord, in this judgment, my lord. In the backdrop of drop of the above, if the court takes into consideration the admit card of the petitioner and the communication dated 14/11/22 issued by the office of the principal AG it would be apparent that the date of birth of the petitioner is 4/10/61. However, the authority responsible to insert the date of birth of the petitioner in service book, in spite of the admit card forming a part of the service book, seems to have wrongly calculated the date of birth be 4th October 1962 instead of 4th October 1961. This mistake could have happened taking into consideration the matter in which the date of birth was recorded in admit card as 16 years 4 months 27 days as on 1/3/78. But even during periodical attestation so made as could be seen from the service book, and when details as regards approval seeking the reconstruction of the service book number 2 was sought from the higher secondary department, it never came into the light either the petitioner or even the authorities about the mistake committed in entering the date of birth. It would also be relevant that admittedly in all document, passport, PAN card, voter list, Aadhaar card, the date of birth has been mentioned 4/10/1962, which is a pointer that petitioners bona fide believe that her date of birth 4/10/1962. Under such circumstances, the petitioner is allowed without any objection to continue to render service till 31/10/22. Next, my lord, paragraph 22, my lord.
Yes.
The above aspect of the matter are a clear pointer to the effect that the opinion of this court that it was the duty of the respondent authorities, more particularly the respondent number 3, to have correctly recorded the date of birth inasmuch as the admit card of the petitioners are available with the said authorities. This aspect of the matter can also be seen from the note SR 8 as quoted in the previous segment.
Do you have the service book available?
It is annexed, Lordship, page 38.
No, that's only the first page.
Yes, wherein the date of birth is mentioned, Lordship. I can furnish the original, no issue, Lordship. But there also same date is. Now, Lordship, what Lordship will consider, in the service book, it is mentioned as 56. In all other service documents, Lordship, at page 24, he has annexed. This is the GPF sheet, Lordship. Therein, his date of birth is mentioned as 56. In the regularization order, it is mentioned as 56. And till, by following that date, Lordship, he should have retired in the year 2016.
But who will put him to notice?
But till 2016, Lordship, he never objected to the date of birth, and he never filed any application for correction of date of birth.
Your inquiry findings say that 2016 he should have gone.
Yes.
Yes.
Now, who will make it known to him? The employer. His salary statement is prepared, signed by the DDO.
Yes.
So while doing so,
that is another aspect, Lordship. But here in Lordship, what he has prayed? He has prayed for correction of his date of birth.
He has abandoned his prayers now. He has modified his prayers orally.
Lordship, in that situation, Lordship, in an appropriate petition, Lordship will pass appropriate order. As he prayed for not deduction, recovery, not permissible. Is that prayer in the writ petition, Lordship? Any prayer, any pleading? Nothing is there. His only prayer is for correction of the date of birth. And my submission will be whether at this stage any correction in the service book can be allowed or not. That is the only issue, Lordship.
That he has already abandoned.
Then it's over, Lordship.
Then he is abandoned.
It should be over. Then.
His only ground is allow him pension. And don't
for pension also, Lordship, if Lordship one goes through one document, Lordship, even
that is not issued to me, my lord.
Which one?
I have seen it.
That is not there in the record. Lordship.
Not there in the record.
Yes,
Lordship, he has already been instructed to furnish his family details.
Never issued to him.
Lordship, may kindly see down below. It was issued to him only, Lordship.
That also was issued in 2020.
Yes, he never responded.
No, not issued to me, my lord. I did not receive.
Okay, heard Mr. H. Class Learned Counsel for the petitioner. And Mr. Naik. additional AG representing the state.
But so far as his judgments are concerned, Lordship, the judgments are also not similar to the present situation, Lordship. In all the cases, it was a mistake of the authority while calculating the date of birth from the admit card. So that was the mistake committed by the authority, and on that ground, petitions
We are
were
not ordering for correction of date of birth.
no recovery.
Recovery will pass some order.
Lordship, in case of in the judgments, Lordship, for recovery, Lordship, Lordship, I am showing his judgments only, Lordship. One judgment is there. This is 7563/2022. This is Sarmilare. Sarmilare. If Lordship comes to paragraph.
The only parameter necessary to decide whether recovery is to be made or not is whether you can settle on him the responsibility of overstay. You can settle on him alone. You are the employer, you give him salary, he is working. He continues to work. His pay bills, salaries, statements are cleared by the officer. He is earning, he is going on. Suddenly somebody wakes up one day and realizes, oh, this man should have retired 4 years ago.
Lordship, even if no intimation has been given.
No, that is a different issue.
That is Rule 95.
No, that doesn't give him a right to continue.
Yes.
But the question is, should he be settled alone with the responsibility?
Yes,
Is it not the responsibility?
And that is why I placed the judgment Sukhumar.
Is it not the decision of the department that you should find out?
Lordship, my submission is that till 2016, he never applied for any correction. So it was to his knowledge that I am retiring in 2016. Lordship, all this PAN card, Aadhaar card, identity card, these are subsequent documents. 2020, 2018. These are subsequent documents.
Can you show that these were documents on which were referred to in official correspondences during his
Never,
service?
never. These documents were never furnished before the authority.
That's right.
So he never applied for correction.
You conduct an inquiry and you settle the responsibility on some other person.
Two persons, one him, the petitioner, and one official.
Did not take the matter beyond that.
No, that inquiry report also is not under
The only conclusion that we can arrive at of the inquiry report is to show that the department has settled the responsibility on him for oversight.
Yes. And we started processing the pension papers also. We noticed him. You furnished documents.
No. See, in a department, there are X number of employees. They are to be paid their salary. That salary statement has to be processed by some authority.
The law is suppression is also a misrepresentation.
Where is that? The finding of the inquiry report is that some manipulation. How have the manipulation conducted, and who else is responsible?
Petitioner and another employee, Lordship.
How can the inquiry report come to a conclusion?
Lordship, that will be a subject matter, Lordship, when that inquiry report is under silence.
That's right.
Until and unless that is under silence, Lordship will have to accept it as it is.
There is no question of having to accept it. This inquiry report is not under the orders of the court.
Yes.
You are conducting an inquiry report.
And that is not disputed by anybody. Has it been disputed by the petitioner?
We have heard you.
Lordship, my only submission will be, Lordship, that Sukhumar Dey, that is why I placed the judgment.
We'll record everything.
Lordship, my only submission, Lordship, will record. It was up to his knowledge that he is retiring in 2016. And till 2016, Lordship, he never objected to that date of birth that is mentioned in the service book. And my submission will be, in spite of knowing fully well that he is retiring in 2016, he continued in service. And that suppression amounts to misrepresentation. That is my submission, Lordship.
No. It will go against my
Counsel for parties, which the petitioner before this court was employed as master roll worker. Master roll labor in PWD Rural Road Division, which services he had initially joined on 18/7/1985 on casual basis, and thereafter his services were regularized on 7/10/2025. Stop. Petitioner continued in his service until he was served with a notice on 30/09/2020, directing him to, issued by the executive engineer, PWD, Patacharkuchi Territorial Road Division, Territorial Road Subdivision, Patsala, directing him to appear before the inquiry committee for his overstay. The petitioner participated in the inquiry, and the inquiry report concluded that the records in respect of the petitioner, including the entries, particularly his date of birth in the service book, were manipulated by the petition by the dealing assistant Sri Mahananda Sarma, Sri Mahananda Sarma, in connivance with with the present petitioner. Stop. The inquiry concluded the petitioner, in terms of the records available in the department, was to retire from service on 31/12/2016, but continued to overstay. Due to manipulation of the records. And incurring financial loss to the government exchequer to the tune of rupees 124,613. Stop. The inquiry, the inquiry also concluded initiation of disciplinary action against the said Sri Mahananda Sarma and the writ petitioner, and for recovery of the said amount. So, the petitioner before this court has submitted that there was a wrong recording of his date of birth in his service book, showing it to be where is the service book?
Page 38 of my affidavit.
(31/12/1956), when his actual date of birth, as per his school certificates, was 28/7/1966. Stop.
No,
This
Lord.
date, according to the writ petitioner, is also reflected in the PAN card, Aadhaar card, as well as the ID card issued by the department. Stop. The petitioner, the learned counsel for the petitioner, submits that since the petitioner is a grade 4 master roll worker, he continued to be in service and was under the bona fide belief that his date of that he would superannuate from service in which month? July 26.
26.
July.
July 26.
In the month of July 2026. Stop. The writ petitioner therefore continued in his service and continued to render service and was accordingly paid his salary till the month of July 2020. Stop. With effect from the month of August 2020, his salary has been stopped. And being agreed, the present writ petition has been filed. Stop. The writ petitioner's specific prayers in the writ petition are for setting aside of the order, the communication dated 3009/2020, which was issued by the department requiring the petitioner to appear before the inquiry committee. Did you appear before the inquiry committee?
Yes, madam.
And also to release his area salary with effect from the month of August 2020 till his reinstatement in service as a master roll worker, and for correction of the date of birth in his service book by incorporating 28/7/1966 as the date of birth instead of 28/12/1956. Stop. The learned counsel for the petitioner submits that there was no complaint against the services rendered by the petitioner during his service tenure, and he continued to render his service until he was informed in the inquiry proceedings that his date of birth was recorded as 28/7/1956, 28/12/1956, and thereby he was required to retire from service, ought to have retired from service in December 2016. Stop. It is submitted that there is no fault on the part of the writ petitioner. And he continued to render his service on the basis of his bona fide belief that his date of birth was so and so month 1966. And it was the responsibility of the department to intimate the writ petitioner prior to his retirement that his date of birth was 28/7/1956 as found recorded in the service book. Stop. Learned counsel for the petitioner therefore submits that the prayers made in the writ petition be allowed and the petitioner be directed to be released his arrear pay as well as arrear pay and be allowed to be reinstated in service. Better. The case projected by the writ petitioner is contested by the respondent by filing an affidavit. Mr. Nayak, additional AG appearing for the state, has strongly opposed the case projected by the petitioner. It is submitted that the writ petitioner was deliberately overstaying in service, knowing fully well that his date of birth was recorded as 28/12/1956 in the service book. This is also reflected in the salary slips and
Page 28, Lordship. Page 24.
Yes.
Page 24 of the writ petition, that is the GPF, PF account.
In the GPF account also, in the statement of the GPF account, it is also clearly reflected that his date of birth is 28/12/1956. Therefore, it is only after his superannuation that the petitioner has now projected a case that his correct date of birth is 28/7/1966.
Lordship, one document remain, Lordship, that is at page 39. That is the school certificate that is, we are having, Lordship.
39.
Wherein, Lordship, this is the school certificate that was furnished to us initially. And wherein, Lordship, it is clearly mentioned as 31/12/1956. And on the basis of this document, Lordship, all the dates were incorporated in the official documents.
Where is this available?
Official record?
Then you get the records. Let us see.
Lordship,
This is a
it was
part of the service book.
on the basis of this date, Lordship, service book was prepared.
You get the records then.
Lordship.
Where is the school certificate enclosed by the writ petitioner?
He enclosed 66.
Huh?
He enclosed
Page
another
number?
one. That
Page number?
page, Lordship,
21.
21. That is from another high school.
Same date.
No, here issuance date of issuance same.
Huh?
27/5.
Same date.
No,
Same
84, I have that copy.
Huh?
24, 27/5.
Date of issuance is same.
Same. School different.
All right, you will continue with the order. During the course of the arguments, the learned additional AG is referring to the documents placed before the court in the pleadings, refers to a school certificate dated 27/5/2005, issued in favor of the writ petitioner by the principal, Paka Higher Secondary School, Pingwa. By the said certificate, the date recorded by the school in their admission register was shown as 31/12/1956. Learned additional AG therefore submits that it is on the basis of this certificate that the entry of date of birth in the service record was issued, was entered, stopped. Para. At this stage, the court has noticed that the school certificate enclosed to the writ petition at page 21 was issued by the headmaster/headmistress of Kayakuchi. What is that? What high school?
Kayakuchi Milon, I have the original copy.
Milon High School.
High school.
Which was also issued on 27/5/2005 in favor of the writ petitioner. And the certificate available with the department as placed before the court by the affidavit is also shown to have been issued on the same date, that is 27/5/2005, but from a different school. Under such circumstances, this court considers it appropriate to call for the original records pertaining to containing the service records of the writ petitioner. Let these records, along with the service book and other relevant documents, be placed before the court. The department will ensure that the birth certificates, school certificates, on the basis of which the department has placed reliance on, be also made a part of the record that is called for. List again after, we'll give you a fixed date.
3 weeks, Lord.
21?
November.
Huh?
Yes, Lord.
21st November.
Acknowledgement.
Mr. C. Borua appears for Accountant General.
That's one number 2.
What documents do you have? Nothing.
So far, there is,
Papers are
is
not,
the-
papers are not forwarded.
No, this, this whatever allegation, this prayer is there. This, we cannot mitigate this one, it's not for us, that is there.
No. The pension papers are not forwarded.
No. Okay, thing is written. Thereafter only our rule will come together. Arrears like they will pay. Pension paper, it will be. Eh?
We'll examine that.
Acknowledgement.
Yes.
I think order.
Yes.
May it please your lordship. This matter basically is related to upgradation of the petitioners. Lordship, these petitioners were actually the erstwhile employees of the Kachar paper mills. So there was basically a government of Assam as well as the employees association have a meeting and they have decided that these employees of the Kachar paper mill will be absorbed in the state government. So, and therefore they have to be absorbed as part of their qualification. That is basically the, and then the basis of that fact, these persons, all these 3 petitioners were appointed, but they were given appointed in a grade 4 post, whereas they were otherwise should have been appointed in the grade 3. Basically, this is the case. Lordship will kindly take up first the minutes, that is at page 26. This is the minutes between the parties. I will not read the whole minutes. Your lordship will kindly turn to page 27, paragraph 4. Government of Assam will provide permanent job to 100 young officers and workers as per their qualification at the entry level and equivalent to the pay scale of the state government against the appropriate post by condoning the upper age limit and taking up special recruitment drive. They will be provided PF gratuity, pension and other statutory dues, but not salary. The list of officers and workers will be prepared by the association and unions in order of the youngest to the oldest. However, if any officer does not wish to take up the job, he will be provided all the benefits under the rate. So basically, 100 officers will be given permanent job by the government. That is as per their qualification. This is what they have decided. Then your lordship, subsequently thereto, at page 31, a screening committee was constituted, page 31. And this screening committee, after screening the various employees who wanted to work, have decided upon certain numbers of employees who were otherwise eligible to be appointed, who were willing to be appointed. Then your lordship will find at page 32, there was another meeting between the government of Assam and the employees of Hindustan Paper Corporation. Here at page 33, para 3, your lordship will see, initially it was para 3. Initially it was agreed that the workmen employed who will get the government job will not get any above mentioned 24 months salary. However, under the changing circumstances, it is presumed that liquidator will give partial salary amount to workmen. The government of Assam now proposes to provide an amount to the employees to also proportionate to the amount paid to the worker as salary from liquidator who will get government appointment, so that equal treatment is given to both ex-employees and the worker. So ultimately that salary part has also been decided in favor of these persons. Now your lordship, what has happened? The 85 out of the 100 that they have decided to, 85 have been appointed. And from the appointment of 85 at page 35, your lordship, this is the number of persons to be appointed on various departments have been decided at Annexure 6, page 35. That is the 31st of August 2022 letter. Here, your lordship, in a particular department has been shown, and grade 3 and grade 4 of various departments. These are the number of posts that will be given to the employees. Here it is shown as 66, ultimately 85 have been appointed. Here also, in this case, your lordship will find at page 36, at the top, while appointing them, the following criteria may be followed, and at that is at the below of at the last part of 35, it is stated while appointing them, the following criteria may be followed. So the first criteria, the appointment shall be made by the corresponding appointing authorities of the departments in pursuance to decision of the Honorable Cabinet on the matter. Number 2, the qualification of the officer to be absorbed should be equal or more than that of the considered post. Now, my whole case rests on the second part. The qualification should be equal or now in this case, I'll come to that, your lordship. Now your lordship will kindly turn to the Annexure 7, Annexure 7, A, B, and C. These are the appointment letters. Page 44. This is the appointment letter at 17 September 2022. Page 44 is the appointment letter of the first petitioner. Then your lordship will find at page 46 is the appointment letter of the petitioner number 2 and the petitioner 3 at page 48. Here your lordship will see they were the first one was been appointed as workshop attendant, storekeeper. These are grade 4 posts. Now the second appointment letter page 46 it has been clearly stated as grade 4. And the third also your lordship has been appointed at workshop attendant, store attendant at principal industrial training institute. So these are in this post. This post is also of grade 4. There is no dispute that they are not grade 4. They were appointed as grade 4 employees. Now your lordship at page 50, Annexure 8. Here your lordship will see various persons who have been appointed in a part in grade 3 and grade 4. And on the left hand side it's grade 3 and the right hand side is grade 4. Grade 4 are the three petition. Page 8, 50, 50.
50.
Here your lordship will see at grade 3 at the left hand side, grade 4 at the right hand side.
Yes.
The right hand side, your lordship, are the 3 petitions. And the left hand side are certain other persons who were given grade 3 posts. Here your lordship will see the qualifications of in the left hand side at grade 3 your lordship will see one is a BA, that is fine, he's a junior assistant. Then another second one has been given SSLC ITI, he has been given electrician. Then third is also SSLC ITI electrician. Then fourth is SSLC ITI electrician. Fifth is SSLC ITI electrician. These are given grade 3 post. Now your lordship will see on the right hand side that grade 4. Petitioner BA, Diploma in Computer, ITI, National Apprenticeship, so and so. He has been given grade 4. Then the petitioner number 2, BA, BEd, ITI, given grade 4. And the third is BA, ITI FITA, grade 4. So, those persons who were equally or less educationally qualified were given grade 3 posts, whereas the petitioners, even though qualified and having higher educational qualifications, were given grade 4 posts. This is basically the challenge. Now there at page 51 also various other names have been given. I am not reading all those. All are in grade 3. They are either they are SSLC or just ITI, but they are given grade 3. We are given grade 4. This is basically the case. Now your lordship will see from the affidavits filed by them. Others are your lordship. There are various communications made for giving them to the higher scale or higher grade. These were between the petitioners and the government and the departments, and these are also annexed here. I'll not go into all this. If required, I'll come later on. As of now, they have prayed for upgrading them into grade 3. That has not been done. Therefore, they approached this court. Now, your lordship will kindly see 2-3 affidavits have been filed by all the respondents. We have also filed reply in of the 2 of the respondents which are required to be filed. So the affidavit of respondent number 3, I think that was filed the earliest. That is why I'm taking it up. And I'm not sure whether the paginations will be same or not. We are given the pagination as 91. Affidavit in opposition filed on behalf of respondent number 3. Lordship has got that. Here your lordship will kindly turn
Who is
to
respondent 3?
respondent 3 is the
MD.
is the AIDC. Managing Director, Assam Industrial Development Corp, AIDC. The whole process has been done by them. So I'll come to that. So here your lordship will see at paragraph 7. Paragraph 7. This is the paragraph where basically they have taken into consideration all the issues that were raised. I'll just read this paragraph. With regard to statements made in paragraph 8 of the writ petition, the deponent denies the averments made in the said paragraph and states that as per letter dated 29/12/23 issued by the Joint Director of respondent number 2 in terms of government notification number so and so, dated 15/10 so and so and ABP so and so, the educational qualification, just I'll point it out. The educational qualification for appointment as junior assistant in head office and district and subdivisional offices is bachelor's degree from a recognized university or any other examination declared as equivalent by the government. The educational qualification of petitioner number 2 is ITI as per statement of government, and accordingly he was appointed in grade 4. The grade 4 post in the office of Manager District and Industries Commerce, Hosai. Moreover, subsequent to order number so and so, a corrigendum was issued whereby the place of posting as junior assistant appeared in Annex 7A of the petition was rectified to the place of posting as grade 4. The petitioner has concealed the material fact and approached the honorable court with malified intent. Now they have only stated that respondent number, petitioner number 2 is not a graduate, but they, in order to be a junior assistant or a grade 3, they have to be minimum a graduate. And they have stated it only with regard to petitioner number 2. They have not stated anything with regard to petitioner 1 and 3. Now your lordship will kindly go to para 8. I'll come to the annexes later. Para 8. That in this in regard to the statement made in para 9 of the petition, the deponent denies the averment of the said paragraph and states that factually the correct position being the government Assam conducted a special recruitment drive from the list submitted by the Association of Ex-Employees and Ex-Workers Union of HPCL. Again, by letter dated so and so, Deputy Commissioner Hailakandi forwarded the verification report prepared by the screening committee verifying the original educational qualification and technical qualification, marks obtained, certificates, etc. to AIDC. Petitioner number 1, 2, and 3 names appear at serial number 11, 44, and 42 respectively. So, thereafter, by letter dated so and so, forwarded the verified list of 85 numbers of ex-employees of HPCL limited candidates to the Secretary to the Government of Assam Industries and Commerce PE Department. It is worthwhile to state herein Deputy Commissioner Hailakandi has verified the documents of 67 numbers of employees of Kachar Paper Mill of HPCL. Deputy Commissioner Moregaon has verified the documents of 15 numbers of employees of Nagaon Paper Mill. HPCL AIDC Limited has verified the documents of 3 employees of CHQ Kolkata, totaling 85 numbers of ex-employees of the erstwhile HPCL. It is stated that the AIDC has neither issued any appointment letter nor made any recommendation as to appointment of the candidates against the post in any departments of the Government of Assam. In fact, the appointments were made after following a procedure and appointment letters were issued by the
Have you
respective
represented
departments.
before the authorities?
Yes.
Have you represented before the
Yes,
authorities?
that is what I said, that I have already made the representations
What
before
is
the
their
authorities
reply?
in the writ petition. The
What is
various
their
documents
reply?
that I have annexed. I'll come to that if required.
What is their reply?
That is what I'll come. Your lordship will kindly take up page Lordship will take up page 112, annexure B in that affidavit itself.
1-1,
112.
yes.
They only replied with regard to the petitioner number 2. That's why I'm just pointing it out. In page 112, this is the letter dated 29th of December 23. With reference to the above, I'd like to inform you that as per government notification by so-and-so, copies are enclosed for appointment of junior assistant in head office and district subdivisional office. Requisite qualification is bachelor's degree from a recognized university or any other examination declared equivalent by the government. The educational qualification of so-and-so was recommended for appointment under so-and-so is ITI as per statement submitted by government, and accordingly he was appointed in grade 4 of the office of the manager, District Industries and Commerce Center, Hosai. Now your lordship will kindly take up page 118. This is the verification document. 118. Their affidavit, your lordship. 118. 25th of April 2022. This is the verification of original documents of 100 ex-workers and employees of Hindustan Paper Corporation, Panchgam. Here your lordship will see at next page, page 119 are the verification names of the persons. So here your lordship will find the name of the petitioner is at serial number 11. Now serial number 11, if your lordship sees, serial number 11 educational qualification at the column number 1, 2.
This is petitioner number?
This is the first petitioner.
1.
Roman.
2. No, 1.
1. Sorry, petition number 1. Petitioner number 1 is at serial number 11. 1 to 1. Not 1.
Is ITI.
No, I'm just showing your lordship. He's at serial number 11. He's initially first, second, third column is the 10th. The next column, that is 48.40% in 10th, 52% in 12th, 64% in BA, and 72% in technical part. So lordship will
So
see
he's a
that
BA and an ITI.
BA and ITI. BA, your lordship, is the first, second, third, fourth, fifth.
He
That
is
is
appointed
64%.
as grade 4.
He has been appointed in grade, though he has got graduation as well as your lordship.
Where is the petitioner number 2?
Petitioner number 2, your lordship will find at page 120. The 124. Page 124, serial number 42. Okay. Serial number 42 is petitioner number 3. Serial number 42 is 3 and 44 is 2. 42, your lordship, he also got BA, 42.1%. And 44 is also BA with 38.7%. And 42, the petitioner number 3 has also got BA, this has been shown, as well as your lordship in the next column. It is ITI, and the percentage has been given as well there.
Yet they are grade 4.
They were given grade 4, whereas the they say that it is the graduate should be, and then in the letter they said that he is not a graduate. When we made an application, this letter was issued that he is not a graduate.
Who has conducted this verification?
This verification by the Deputy Commissioner. It is at page 118 by the Deputy Commissioner Hailakandi.
And who has filed this affidavit?
This affidavit has been filed by AIDC, and the affidavit filed by.
Is the AIDC required to re-verify?
No, there is another affidavit your lordship will see who has been filed by petitioner number 1, 2 and 1, 2 and 9. So that is by the state government. Now I'm taking your lordship to that affidavit also. It is exactly the same affidavit. Exactly, even the paragraphs are the same. Your lordship turn to paragraph 7. Kindly turn to paragraph 7. Your lordship has already read the paragraph 7 of respondent number 3. Now kindly read the paragraph 7 of the respondent number 1, 2 and 9. This is the government, state government. In this regard, the statement so and so, they have stated the educational qualification of junior assistant is a bachelor's degree. Exactly the same has been stated. Petitioner number 2 only has been stated. The other petitioners have not been stated. Exactly the same wording, the same affidavit with same annexes has been given. Here also, your lordship will kindly turn to page 10. I don't know whether pages match or not. Here it is shown as 108, Annex 2. That is the same letter that I have read. Then, your lordship, that 25th April 2022 annex that I have shown by the Deputy Commissioner of Hailakandi, that has been annexed, and the names have been the same names that has been annexed in the affidavit filed by respondent number 3. Exactly the same affidavit has been filed by the respondent number 1, 2, and 9. So there is no difference in the affidavit at all. Here, your lordship, these are the names which has been given.
Yes.
So, in a nutshell, your lordship, what they wanted to say is that since he or the petitioners are not graduates, they were not given grade 3, they were given grade 4 from the letter issued with regard to only respondent number, petitioner number 2, it has been stated.
From the evaluation made appears to be incorrect.
It is incorrect. That too is incorrect. The other two, they did not even mention anything about it.
Anything else?
This is basically the whole case as of now. But one more affidavit has also been filed by the respondent number 4 to 7. In that affidavit, basically, your lordship, the 4 to 7 are basically the Secretary to Govt of Assam, Skill, Employment and
Who makes the appointment? Who makes the appointment?
No, there are different departments, your lordship. So, with regard to petitioner number 1, he was appointed by I think, by the respondent number 5. And the petitioner number 2 and 3, I think, by the respondent number, one is by respondent number 5, ITI, and one is by the respondent number 6. So these 2 of them were in
You've
ITI.
already joined.
Huh?
You have joined in your.
No, we have joined. We are working. We are working. We are working. While we are joined.
What orders do you want from the court?
That we are entitled to be upgraded to grade 3 as per the norms, as per the discussions as per the cabinet decision, as per the decision of the ex-SPCL employees and the government, where they have stated the educational qualification, the appointments have to be made. They were made appointed, but they were given one post lower, that is grade 4. They should have been given grade 3, number 1. Number 2, your lordship,
Now,
other persons who
the
were
orders that you are seeking from the court
is basically that they should be appointed as per their
order
education.
is to be implementable.
Yes, because they are given grade 4 posts, whereas they were otherwise eligible to be grade 3.
No, but your appointments.
But
you
their
are asking for
justification,
upgrading.
even if we take their justification that only persons with graduation were given grade 3, then
Well,
we are
let us-
entitled to that.
Let us hear the response.
Let them.
Yes, apparently they are graduates. You are saying they are not graduates. Why?
My lord, I am appealing for respondent number 4, 5, 6, and 7, my lord. But petitioner number 1 and 3 is under our department, my lord. Skill employment, my lord, under the ITIs, my lord. If your lordship see, my lord, we have also filed our affidavit. Before the coming to my affidavit, my lordship may kindly come to the minutes, my lord. At page 27 directly, my lord. The clause number 4, which have been shown by learned friend, my lord. It says, my lord, in the last paragraph, my lord, however, if any officer workers do not wish to take up government job, he or she will be provided.
Clause number
4, my lord, at page 27.
4.
Last second line. However, if any officer worker does not wish to take up government job, he or she will be provided all the benefits under the relief. But so, but they have chosen to be appointed, and they have accepted the appointments. And my lordship may kindly see.
No, that is okay. But what they want to be considered, given the same consideration.
Yes.
Now you have to give an explanation
ma'am.
why that consideration is not given if you have handed it over to them. This is a scheme handed over.
Lordship may kindly see para 9, my lord,
Hmm.
of these minutes on the same page, my lord.
Hmm.
Here, the Principal Secretary Industries, Government of Assam will nominate a senior officer to redress any grievance of the workers or employees.
So who is that officer?
Yes, my lord. So, my lord, as per the Industry Department's opinion, my lord, we have given the appointment letters. If your lordship comes to the affidavit, opposition filed by respondent number 4, 5, 6, and 7, my lord, we have appointed as per the requirement given by the Industry Department, my lord.
Page 119.
Hmm.
Yes, my lord. Lordship may kindly come to page 190. This is a letter issued by the Secretary of the Department to the Director regarding appointment of this petitioners, my lord. As per this letter, my lord, we have made the appointment, my lord.
190.
190, my lord. But petition number 1 and number 3 are under our department, my lord.
190 is what?
190 is the letter issued by the Secretary of the Department.
September 2020. And
3rd of September.
Yes, my lord. But this letter has been issued by the Secretary, my lord, Deputy Secretary to the Government of Assam, my lord, to the Director to make to appoint the petitioners under the department, my lord.
No, so who undertook the verification?
My lord. Okay, my lord.
Who undertook the verification?
Yes, Lordship, kindly go through the, kindly see the page 92, Lordship. It is the affidavit, Lordship, filed by the Deputy Commissioner, Lordship. Yes. The affidavit filed by the Deputy Commissioner, Hailakandi, Lordship. Respondent 8, Lordship. Here, paragraph 6, Lordship. That with regards to the statement made in paragraph 14 of the writ petition, the deponent begs to state that.
Wait,
as Lordship, it is
page
page
number?
Page number 92 in my office file.
Right. District Commissioner Hailakandi.
Yes, Lordship.
Paragraph 6.
Paragraph 6, yes.
Yes.
Yes. The relevant portion stated as per the order, then Deputy Commissioner Hailakandi issued Vice so and so dated 19/4/2022 as screening committee was constituted for verification of all the educational qualification certificates, works experience certificate, and other documents of 100 numbers ex-worker of Kasar Paper Mills SPCL so and so were done at Algapur Circle Office as per the verification list was prepared in a format. It is seen that all their academics and technical qualification except have been recorded duty during verification, reflecting their presence, biodata, post held educational qualification and other information. So the claim made by the petitioner 1 and 2 stated stating their qualification is not reflected in the specific column is devoid of true, which is baseless and so and so. So.
That's right. So if this is the
They have annexed-
qualification, then why have you not?
No, they have
included them?
annexed that. Your
Why have you
lordship
not
has-
appointed them in grade 3?
No, Lordship.
Their qualifications are reflected.
That-
You come
no,
to
it has
page
been-
number
no,
96, page number 96.
96.
Serial number 11, you will find he's a graduate. He is DCAD, whatever that means, and
Diploma
IT,
in computer, it has been written some, diploma in computer.
diploma in computer application. Then comes page number 100. Serial number
42 and
42 and 44. There also the qualifications are reflected. Shows BA.
Yes.
So if it is BA, then they are supposed to be grade 3.
Now, Lordship, yes. Now, Lordship, kindly see the affidavit filed by the industry department, Lordship, is the government, Lordship, industry department. Lordship. Means, 96 page 96. Filed with the respondent 1, 2, and 9, Lordship. On behalf of 1, 2, and 9, Lordship. It is paragraphs 12, Lordship. Lordship, the relevant portion, Lordship. As stated in the preceding paragraphs, it is states that the government of Assam conducting a special recruitment drive from the list submitted by the Association of Ex-Employees and Ex-Worker Union SPCL. Appointment letters were issued by the respective department of the government of Assam. AIDC, as per the direction of the government of Assam, had forwarded the verified list of employees and ex-workers union of SPCL as received from the Deputy Commissioner Hailakandi and Morigaon and HHQ Kolkata to Government of Assam on 4/05/2022. Moreover, the jobs were offered to the petitioners as well as the other eligible ex-employees of the mills on absolutely sympathized grounds out of compensation. As such, they have no affordable right to claim for upgradation of their post. The appointments were made after following a procedure, and the petitioner had choice to decide whether to accept of the job offered or take the relief package instead. That is the principle laid down in the minutes, Lordship.
Where are the minutes?
Yes. Page 26 of the writ petition, Lordship. Yes. Page 26, Lordship. Yes. After details, Lordship, paragraphs 1, Lordship. Page 26, Annexure 2, Lordship, in the writ petition, Lordship. In view of the suffering being faced by the workers and employees of SPCL Limited due to the present status of both the mills at Zagirud and Panchagam, Government of Assam process of offer a general relief package to them.
Where is the order passed by the authority before which you represented? You represented before.
Yes, we represented. In fact, in their affidavit, that is at page 191, they have also referred to my letter, which they have forwarded it to the authority concerned.
191.
191 that my learned friend has shown in their affidavit. Here, Annexure 2. They have, your lordship read Annexure 1, but did not read Annexure 2. In Annexure 2, it has been specifically indicated. After that, in fact, I have in my writ petition, I have given all these letters issued by the
191.
191 that my learned friend has shown. Here your lordship will see, this is a order from the director to the secretary, whereby it has enclosed the application received directly from Saidur Rahman Borbhuya regarding prayer for consideration of his appointment to a suitable post as per educational qualification following the point number 4 of MOU so between Government of Assam and so. Copy enclosed, and it has stated that he has been appointed in grade 4.
No, we only want to know what is the basis for classifying. Who will be in grade 3, who will be in grade 4? What is the basis?
Kindly come to clause number 4.
Uh,
There's 3 points which will be the basis for one. Clause number 4, Lordship, the page 27. Clean minute. I'll just point out to that effect only, Lordship.
yes.
It says Government of Assam will provide permanent government jobs to 100 young officers and workers as per the educational qualification 1 at the entry level, that is the second option, and third is equivalent to the pay scale in the state government. That equivalence is to the post they were serving in the Kacha
where
paper,
are the
which
details?
they have not annexed the appointment letters, which doesn't say which grade they were in. And
Who
other
has made the selection?
Lordship,
Who made the selection?
the respective departments where they are serving.
So the respective department, while making the selection,
Yes, Lordship.
in terms of clause 4,
Lordship.
you think that this person is best suited to do this particular job? There has to be some finding by the authority.
The findings,
On what basis are you classifying? Out of all these 100 employees, how are you distributing some in class 3 or some in class 4? Is it by way of lottery?
No, Lordship, not by the way of, but the grade they are serving in, except few.
So the grade that you're serving in requires an inquiry.
Absolutely, Lordship.
Application of mine, where is that?
That is,
In which affidavit have you reflected it?
Lordship will then allow us to come back with that proper.
What allow you? You have filed affidavits upon affidavits saying the same thing. And then when the matter is open for hearing, you want further time.
Lordship, only with that aspect will come back with the instruction, Lordship.
The whole case is based on that, and you have filed 3 affidavits and yet you don't have an answer.
So we'll come back.
Then you have wasted more than half an hour.
And Lordship, with
making the court traveling from 27 to 215.
Lordship, that is correct.
I sometimes get the feeling that we should call the officers instead of listening to your lawyers, to the lawyers. I'm sorry. You don't have instructions.
And with regard to the department I'm representing is only.
Whatever department you are representing, once you address the court, your instructions must be complete, or you don't address.
Lordship.
Yes, Mr. Goswami. Who is in charge of your department? You please call him. With all records, we'll see for ourselves, instead of wasting further time. We are not examining how craftily you can draft your affidavits. We want to know what is your stand.
Lordship, it is the page 27.
How have you made the selections?
Yes,
and
on the basis
distributed the posts in grade 3 and 4?
On the basis of their on the basis of their
Where is
entry
that
level
exercise
equivalent to
evident?
the.
Where is that exercise evident from? Which
It is-
record?
It is from the my notes, Lordship.
My notes have given the parameters.
Yes, Lordship. Yes.
You have applied the
I will
parameters.
come with the record, Lordship. Selection record, Lordship.
Tomorrow,
Tomorrow, it will be difficult.
day after,
Day after, Lordship. Day after. From industry department,
Thursday. After hearing the counsel for the parties at some length, the court on a pointed query made to the respondents as to how this election an appointment of petitioner vis-a-vis the other erstwhile employees of what? Kachar.
Qatar Petroleum.
Paper mills were made in grade 4 and grade 3 and grade 4 posts on the various departments in terms of the minutes dated so and so, more particularly with reference to clause 4 of the said minutes, page 27, second. The learned counsel for the respondents submit that the selection records are not available and they would like to make further arguments on the basis of the records to be called for. Accordingly, let the matter be listed as agreed to. Let the matter be listed again day after. Which date?
Lordship, today is the holiday, Lordship, in the state government office, Lordship. Can it be on Friday, Lordship?
No, Friday is not a hearing day.
Then Tuesday, Lordship, next Tuesday, Lordship. Next Tuesday,
All right, on 4th,
Lordship.
matter be listed again on, what is this item number?
18, Lordship.
18.
18. 18.
And let it be on 6th.
6, Lordship.
In fact, in their affidavits, they have indicated that the qualification is graduation. Since I do not have graduation, that is why I have not.
Two
been-
parameters are there.
Let us see
Yes,
what,
Lord.
That
what
they have
records,
printed it.
how have you distributed it? Let us see that.
Yes, okay.
And also get the instructions, who is that officer who is assigned to look into the grievances of the persons. Some industry department is supposed to depute.
That we have already.
That is
they-
there. That is there.
Minute.
Yes.
Who is that officer?
Lordship, I will take the instructions.
Obliged.
I will take it.
Like,
I think 49.
Here, Lordship, a reply has been served on me today, Lordship.
Wow.
Probably it has not gone into record. I may be allowed.
Mr. Dr. G.J. Sharma appears for the writ petitioner. He submits that counter affidavit.
Affidavit in opposition.
Opposition.
Affidavit in opposition has been filed on
Mr.
behalf of
Respond about 3 minutes.
respondent number 3 in this during the course of the day. Stop the same, therefore, is not available in the case record registry to verify the same and connect the said affidavit to the case record. Matter be listed after 3 weeks.
2 weeks.
3 weeks, and the writ petitioner may be permitted to file rejoinder affidavit if so advised.
Interim may be continued.
Interim order passed earlier will continue until further orders.
Obliged.
Daily list for hearing item 30.
My pleasure. Mr. Kaur was there for PWD. Even the petitioner has not given promotion, considering that one DP has been pending against him since last 2020. What is? Huh?
he needs to complete it.
Departmental proceeding not concluded. Yes, ma'am.
Not concluded.
Where is this? Why?
No, but Lordship, so far as his promotion is concerned, Lordship, nothing was kept under seal cover, Lordship, because he was found ineligible for promotion, Lordship. It was considered
There's a difference between pleadings and the annexes, my lord.
not being found eligible, he was
No,
not
my lord.
considered for promotion.
In a minus, my lord, it is
Not,
not
be-
related, my lord.
not because of the departmental proceeding.
No, my lord.
But one affidavit is there, Lordship, to that.
First DPC, my lord, 6 DPC has been constituted, my lord. First DPC is page 86, my lord. Yeah, affidavit, my lord.
Page.
Page 86, my lord, the first DPC, my lord.
Fifty-six.
86, my lord. Our relevant portion is at, my lord, page 93, my lord. This is chart has been prepared by them, my lord. Serial number 101, my lord.
In page number 87, where is your name?
86, my lord. 86.
86,
Yes, my lord.
then
But
87.
these are the officer has been considered for promotion, my lord.
Your name is not there.
Yes, but there's a list, my lord. They have prepared, my lord.
No,
Page
no.
100.
In the page number 87, there is
Yes.
a chart.
Yes, man.
There
35
is a
numbers.
table.
35 numbers, man.
36.
36, my lord.
So is your name available there?
No, my lord. Now, my name is reflected in page number 93, my lord.
93.
Yes, my lord.
This
So,
is the promotion
yes,
to
my
the
1:4
post of
from my lord, post of my lord, assistant executive engineer to executive engineer civil, my lord.
ratio is 1:4.
Yeah, Mr. Paul. Page 93, my lord. My name is reflected, my lord. 101, my lord. 93, my lord. CL number 101, my lord. Five years SCR has been, my lord, considered, my lord. And in the affidavit pleadings, my they stated that the SCR is not available with the department, my lord.
ACR is not the only ground. ACR is
Your
also
name,
there.
your name is at serial number
101, my lord.
101, Lord.
Yes,
Page 92.
01.
Yes, ma'am.
Lord, may kindly see the last column.
Last, my lord, not submitted.
Not submitted.
API is not submitted, my lord. Now, my lord, in 2025, my lord, the API has been submitted, my lord. Now, second DPC, my lord, will find it by page number 96, my lord.
There.
There, my lord, page 100, my lord. CL number 56, my lord. Remarks column, my lord, DP, my lord.
Lords, may kindly see the previous column also.
It says not applicable, my lord.
56.
Yes, serial number 56, man. On the bottom is 6 line, man.
DP.
Yes, my lord.
No, two grounds, Lordship. One is not applied, Lordship.
NA means what?
Not applicable.
Not applicable is not there in Lordship. May you kindly see the heading of the column, Lordship. APR statement 2020. Others have submitted, in his case.
Not available.
Not available.
Yes.
Where have they gone?
In
Where?
25, my lord, in February, they have submitted, my lord.
So this time his case will be considered. If Lordship comes to my affidavit, Lordship.
Yes, my lord. Then I will show, my lord.
Page 82.
Then my third DPC is at page 107, my lord. My name is reflected in page number 109, my lord. In 150, my lord, the third
109. Serial
yeah,
14.
yes, my lord.
Serial number 14.
Yes, my lord. Not available, DP. Remarks column, my lord.
So seal cover procedure will be available only when your DP and everything is available.
Yes.
But it was not kept under seal cover, my lord.
Because you are not
Kept
found
for seal
eligible.
cover for what purpose?
Kindly see my page 115, my lord, for a moment.
115,
my lord. Is the fourth DPC, my lord.
Yes.
Clause 5, my lord. He says that as per the record available, there is no any different proceeding or advice report is pending against 96 number of assistant executive engineer civil, that is zone of consideration for 20 number of the post except Bijoy Kumar Singh.
No. What is your submission?
And my submission is that as of now, the DP has not been completed, my lord.
Okay, that is
Yes.
one.
Yes, my lord.
And the other? That's the only submission.
Yes, my lord. And so far the APR is concerned, my lord, into February 25, my lord, the APR has been submitted, my lord. And in the March, to my knowledge, my lord, in March 2025, my lord, the 7 DPC has been constituted, my lord. And there are also, my lord,
What is the DPC minutes for that?
But that
Second one, line nine,
seven they have not brought into the records, my lord.
Is it there?
Yes, my lord, in March, my lord.
Seven lordship, I am not aware, lordship, that instruction. In the affidavit, 6 DPCs
Six
are there.
DPC, my lord. But last 7 DPC held on, my lord, 20 March 2025.
So now the DPC, what is the status of the DPC?
Lordship. Lordship, so far as my affidavit
what
is
is the
concerned,
status of
lordship,
the
it was
DP?
filed
DP,
in
my
the
lord,
month of February, lordship.
Huh?
And he's saying that the last DPC was in the month of March
March.
or in the month of April, lordship. That instruction I have to obtain, I think.
You get it?
Yes, lord.
The first focus notice was my lord, 2018, my lord. Then, my lord, I have been asked to appear before the inquiry officer 2020, my lord.
I'll have that instruction, lordship. এইবাৰ হেৰি দিব ক'লে এপিআৰটো দিব দিলে।
Heard counsel for parties. Petitioner before this court is aggrieved that the departmental proceedings, disciplinary proceedings initiated against the writ petitioner has not been concluded.
6 of December.
The the affidavits filed by on behalf of the respondent reflects that the further prayer of the petitioner is that the departmental promotional committee for consideration of for recommendation of the eligible candidates for being promoted from the post of assistant executive engineer to the next higher post of executive engineer were being periodically held by the department. However, the case of the writ petitioner was never put in seal cover as required. And that apart, the proceedings initiated against the petitioner as far back as 2018
Yes, ma'am.
has not been concluded till date. Para. Mr. Nayak, additional AG appearing on behalf of the state on the other hand, referring to the affidavits filed, submits that although the DP has not been concluded against the DP departmental proceedings, in the writ petitioner, however, from the minutes enclosed to the affidavit, the petitioner's case was duly considered by the DPC for in its minutes, in its meetings held for recommending suitable candidates for the next higher post of executive engineer stuff. However, since the APAR annual performance appraisal reports for the relevant years in question were found to be not available before the DPC, the case of the writ petitioner could not be considered. Stop. The counsel for the petitioner on the other end submits that for reasons best known to the department, the APARs were never furnished before the DPC. However, to the best of his information available, the APARs were duly furnished before the last DPC held on 23/03/2025. Stop. However, the outcome of the said DPC is not before the court, nor is reflected in the affidavit. Yeah. Learned additional AG therefore submits that he would like to complete his instructions on this aspect. He prays for 2 weeks' time. List again after 2 weeks.
3 weeks.
3 weeks.
Also indicate the API has been submitted on 27/1/25.
The additional AG will apprise the court as to whether the APARs have been
Yes, sir.
submitted before the court, before the DPC.
Yes, ma'am.
And whether the case of the petitioner was considered and the conclusions thereof, if any, by the DPC. And as also the status of the departmental proceedings initiated against the writ petitions lodged, list again after 3 weeks.
I may pay for a date, my lord.
Second December.
Yes.
Obliged.
I know 31 to 35.
My lordship pleases, my lord, these matters will take some time. My lord may hear it on a hearing day.
All hearing days are like that.
Convenient to your lordships.
All hearing days are convenient to me. Subject to convenience of counsel. This is a chart prepared.
My lord.
Have you supplied to the respondents? I do not know who has prepared, but is it prepared by the petitioners?
My lord.
Yes. The counsel for the parties submit that this matter will require extensive hearing and therefore the matters be deferred to be listed again on eighteenth November.
Which, whatever is convenient to my lord.
18 November.
18th
Yes, sir.
or 18 November.
Okay,
My lord, another prayer, if I may.
Since these matters are parted, the registry will ensure the matters are listed higher up in the cause list. Yes.
Obligement.
Anything? Yes, you're submitting something?
No, my lord, I was just about to pray that the matters may be kept parted.
It is already parted.
My lord.
Yes.
Item number
Obliged.
36 also same matter, madam.
Item?
36.
36 to 47.
36.
36 also same, madam.
Same series.
My lord.
All right. 18th.
In 44, lordship, they have not signed their affidavit till now.
We'll see what happens. Because apparently the health issues are different.
Lordship.
So if you can classify the health issues, if some of the health issues which have been disposed of, writ petitions have been disposed of, we can close it. I think some
Skin disease, some disease.
skin and some